May it please your lordship. I beg to mention item number 9, lordship. That has been wrongly listed here because it was part heard before my lord, Mr. Parthasai, yeah.
Heard, Miss S. Chakravarti. You have informed the
Yes,
appellant.
lordship, with the consent.
Heard, Miss S. Chakravarti, learned counsel for the respondent who
May it come up after the vacation.
submits that this matter has been part heard before a coordinate bench of this court. Stop. Let the registry list this matter before appropriate bench after vacation.
Lordships, deeply obliged.
May it please, your lordship. With the consent of the other side, I beg to mention item number 12 and 13, my lord. Some difficulty on my part. I've lost the brief. I'll have to reconstruct the brief again, my lord. So may I take that the matter may be taken now after the vacations, my lord.
12 and 13, you are
12 and-
for?
I'm for the railway respondents.
Heard, Mr. A. Ganguly.
B. Sharma.
Sorry,
B. Sharma.
heard, Mr. B. Sharma. Learned counsel,
Standing counsel and
Standing Council NF Railway, who prays for an adjournment on the ground that he has misplaced the brief, who
May not be recorded.
who prays for an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment today.
Right.
Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after puja vacation.
Right. Much obliged.
May I please, Lordship, I have to mention item number 18, my lord.
20,
I have taken concern from the other side, my lord.
item number
18, 18, my lord. I am about a respondent, my lord, claimant respondent. Is the affiliate, my lord.
You are Mr. M.
A.K. Azad, my lord.
Okay, heard, Mr. Your name is not there.
Yes, I am only Mr. N. Hawk, my lord. He is out of
Heard,
state.
Mr. A.K. Azad, learned counsel for the respondent who prays for an adjournment on the ground of personal difficulties. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment. Stop. The prayer is allowed. Let this matter be. No,
24.
no.
Over, my lord.
After vacation on a date to be fixed by registry.
All right.
May I please, your lordship? My lord, with the consent of other side, my lord, I beg to mention item number 20, my lord. The matter may be fixed after vacation, my lord.
What is the ground for?
My lord, today I have got the memo of appeal, my lord.
Okay. Heard, Mr. F. A. Laskar, learned counsel for the respondent who prays for an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment. Stop. The prayer is allowed. Let this matter be listed after vacation on a date to be fixed by registry.
May I please,
Obliged,
your lordship? I beg to mention item number 25 and 27. My senior is out of station, so please adjourn this matter for today.
Heard, Miss, what is your name?
P. Goswami.
P. Goswami, learned counsel for the. You have informed the other side.
Yes, sir. They consent.
You are appearing for
K.K. Bhatta.
K.K. Datta.
K.K. Bhatta.
Okay. Learned counsel for the appellant who prays for an adjournment on the ground that the conducting counsel, Mr. K.K. Bhatta, is out of station. She has submitted that she has informed learned counsel for the respondent regarding her prayer for adjournment. The prayer is allowed. Let this matter be listed after vacation on a date to be fixed by registry.
May I please, your lordship? My lord, I beg to mention this matter for listing bail application, my lord. It was filed on 12/9, my lord.
What is the matter?
Matter, my lord, analogous matter is pending before your lordship, my lord. The co-accused bail petition.
No, but registry, because now this court is not taking bail roster. This is a civil bench one.
This is right, my lord, but
So
this,
you have to
this matter, my lord, it's earlier rejected by your lordship.
maybe. So whenever I take bail matters, it may be listed. So you have to pray before registry. Yes.
May I please, your lordship? Beg to mention item number 2, lordship. The case diary has not been received.
CD not received, lordship.
Heard Mr. V. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. Miss N. Das, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this matter be listed again on,
After puja.
After vacation.
you are on interim.
Lordship.
On 22nd October, lordship. 22nd.
On 22nd, 10/2024. The interim order shall continue till next day.
Highly obliged, lordship.
May I please, your lordship? I have to mention item number 1, your lordship. With the consent of the other side, matter may be adjourned for 1 week, your lordship.
Lordship, I am for the respondent number 1 in item number 1. Lordship, the matter may be fixed before vacation, lordship.
Any date may be fixed here, lordship.
Tomorrow,
After 1 week, your lordship.
what is your name?
A Hussein, your lordship.
Heard Mr. A. Hussain, learning counsel for the petitioner. Also heard Mr. What is your name?
A Singh, lordship.
A. Singh, learned counsel for the respondent. Learned counsel for the petitioner has prayed for an adjournment on the ground of personal difficulties. The prayer is allowed. Let this case be listed again on 26/9/2024.
Obliged.
Lordship, I beg to mention item number 9 of the daily is lordship. The item number 9 has been part heard by Honorable Mr. Justice P.J. Soikia, lordship.
Item number 9 has been mentioned. Mentioned by, already it has been.
Item number 21 from Liability is.
No one,
Lordship, matter may be taken after some time.
after some time. Oh, you received the case diary.
Lordship, motion nothing.
Okay. After some time.
Detailing here, item 20/23 from Liability.
Hand copy has arrived.
Lordship. I have been languishing in jail for 641 days. That means 1 year, 9 months, 6 days. And lordship, I have gone through the charge sheet, but no specific and clear allegation is found against us. And section 173 of the code are not consistently complied with and followed by the police officer. In column number 16, may
No,
kindly
no,
be.
How many petitioners are there?
3 petition, 2 cases, 2 and 3, 3 total, 3.
In case number 2259,
2259 and 2266,
let us take one by one.
lordship. Okay. So 2259,
2259, when the petitioner was arrested, date of arrest,
date of
17/12/22.
17/12,
22. 2020.
when the charge sheet was laid,
29/4/2023.
23,
Yes, Lord.
23, when the charges were framed,
Charges framed on
29/9/2023. And last witness
how
was
many
examined.
witnesses are listed in the charge sheet?
6 witnesses.
6 witnesses.
And
How
has
many
been
have
examined.
been examined?
2
2 has been
examined.
examined. The last witness was examined 14th of December 2023.
14/12/23.
And since 9 months, no progress.
And Lordship, as per the last order, 17/8/24 for evidence.
What is the contraband? What was found?
Ganja, Lord.
Ganja.
How much?
11.5 quintal,
11 point,
5 quintal,
11.5 quintal,
Lordship,
1100 kgs.
1150 kgs. And Lordship, and the co-accused R. Yaruibu was allowed to go on bail. And I would like to take
Now, who are you?
I am Ibomaya Thapa.
No. How you are involved in this case? Where is the bail order of the co-accused?
Yeah.
Where is the order?
Order
At
number
page?
45, Lordship.
No, yes. Tell me your case. What is your case?
My case is that, Lordship, I have gone through the charge sheet and
Wha-
I,
Make your submission one by one. Huh?
yeah,
Now, regarding 2259.
yeah, 2259. And this is the no separate specific or clear allegation is found against me, Lordship. Please come to the page number. 23. Question 28, column number 16. And here, the last paragraph. During the investigation, the accused persons are forwarded to the honorable court and accused, namely so and so, and are found sufficient evidential proof against the said accused persons under section so and submitted the charge sheet. Here, no specific
No,
allegation.
that is enough.
Lordship, in support of this, this section 173 of CRPC is not complied as per the judgment of Sharif Ahmed and versus state of UT. Paragraph.
No, but from where you were arrested?
I was arrested on the way to
Are you a truck driver or handyman or
I'm a driver, but
driver of the seized truck?
seized truck.
Then what is your case? From that truck, the ganja was seized.
But no
Yes, sir.
specifically mentioned is that two vehicles were coming. One is truck and one is venue car. But from which vehicle the contrabands were recovered, not mentioned in anywhere in the record. Lordship.
Go through this season.
Lordship, in the case diary, Lordship, scan copy of case diary statement is there, Lordship. And he admitted that he is dealing with the this kind of illegal activities since long, Lordship, earlier also.
Lordship,
I
without
have flag mark, Lordship.
Lordship, without compliance of section 173, it is an incomplete charge sheet.
No,
And-
this is not an incomplete charge sheet. In charge sheet, clearly it has been stated that there are materials against you. That
On-
is,
But which materials, which is
that we have,
clear
to
is
say-
not separate.
that is not necessary to be mentioned in the charge sheet.
Then Lordship and principles of parity may kindly be considered in this case also.
Parity is
Lordship.
also not applicable.
And the Anjannath judgment and Nizam Sheikh's is there.
We'll take it up at 2. You go through the case diary. Is there any material against the 3 accused persons? And you also make clear on what ground you are praying for bail. Is it on
Lordship, ground.
Is it
delay
on-
Is there is a common
is-
ground which I have as the.
No, is it on prolonged incarceration
Lordship.
or some other ground?
This is the prime ground, my
Which,
Lordship.
which one?
Delay, ground of delay is there.
So, but you are not making your submission on that ground.
This, step by step, I was going to.
At
ground.
two, we will
I have,
take it
I
up.
have 4 or 5 grounds, Lordship.
At two, we will take it up.
Lordship.
Lordship, whether I have received the telephonic instruction, Lordship, after interim Lordship, he has not appeared before the investigation officer.
I could not contact and because Lordship.
Then then
have the Bandra case, Lordship, so he's.
then we are vacating the, you have the case diary.
Yes,
Materials are against him.
yes, Lordship.
Yeah, if you have not appeared, then the heard Mr. H.S. Bora, learned counsel for the petitioner, also admits petitioner has submitted that the petitioner was allowed to go on interim bail by order dated 28/5/2024 with certain conditions. However, stop. He also submits that you are unable to contact,
Yes, yes.
that the petitioner, the counsel is unable to contact the petitioner and therefore not in a position to inform this court as to whether he had complied with the conditions of condition attached to the said interim bail order of appearing before the investigating officer within 10 days from the date of the said order. Stop. On the other hand, learned additional public prosecutor has produced the case diary. Ms. N. Das, learned additional public prosecutor, has produced the case diary of North Lakhimpur PS case number 56/2024 and has submitted that on perusal of the case diary, nowhere it appears that the petitioner has appeared before the investigating officer. She also submits that she has telephonically spoken to the investigating officer who has informed that the petitioner has not appeared before the investigating officer. So it appears that the petitioner has not complied with the condition attached to the interim bail granted to him by this court by order dated 28/5/2024. Stop. In view of above, the interim bail granted to the petitioner is hereby vacated. Stop. I have gone through the case diary. There are sufficient incriminating material against the petitioner in the case diary, which does not justify granting of protection to the petitioner under section 438 of the Code of Criminal Procedure 1973 at this stage. Hence, the prayer for anticipatory bail is rejected. Send back the case diary.
It's the anticipatory bail application. You will find the FIR at page 15. There are some anomalies regarding, my lord.
Why this has come to this?
Your lordship was pleased to grant interim bail to two of the co-accused. And this matter was last listed before Honorable Justice K. R. Surana because your lordship had granted interim bail to two of the co-accused. So it was directed to be listed here.
Oh.
Take the request.
Yes.
And matter pertains to some financial irregularities under the Ayushman Bharat PMJY scheme. Well, the FIR was lost primarily against the Dr. Abu Sharif Akanda and one Imdad Chand. And 3 pharmacies were also found to be involved in the malpractices. Now, the petitioners before your lordship are employees of the same, one of those pharmacies, my lord, healthcare diagnosis. Now, the FI named doctor, the CHC accountant, Imdad Chand, as
No,
well as the
who are petitioner number 1 and 2?
petitioner number 1 and 2 are the employees of healthcare diagnosis.
Healthcare diagnosis.
Now, healthcare diagnosis is owned by one Islamuddin, my lord. Your lordship will find his interim bail order. at
When
page
when are the other cases fixed?
Cases were fixed today, but case diary was not available and they have been adjourned till 4/10/2020.
410.
4/10, my lord. So I'm praying, my lord, since we are only the employees, the proprietor as well as the FI named doctor and accountant have been granted interim protection, my lord.
Heard Mr. S. Nawaz, learned counsel for the petition. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioners, namely Salim Akhtar Chaudhry alias Salimuddin, number 1. Number 2, Mehboob Ahmad Bardhoya alias Mehboob Alam, who are apprehending their arrests in connection with Doboka PS case number 148/2024 under section 120B/420/468/409 of the Indian Penal Code. The gist of accusation in this case is Code Para 3 from this flag. Back code this. 3 from 2365 bail anticipatory bail application 236. Learned counsel for the petitioner has submitted that the petitioners are the employees of
Healthcare diagnosis, my lord. Pharmacy cum diagnostic laboratory.
healthcare diagnostic. What is healthcare diagnostic?
Well, it's a pharmacy cum diagnostic laboratory.
Which is a pharmacy cum diagnostic laboratory situated at
My lord,
Doboka.
Doboka, my lord.
Doboka.
Doboka town.
Learned counsel, you are not named in the
I
FIR.
am not named in the FIR.
Learned counsel for the petitioner has also submitted that the petitioners are not named in the FIR. However, police is searching for them.
Notices have been issued, my lord. It's okay.
So, learned counsel for the petitioner has also submitted that in the Doboka PS case number 140, in connection with Doboka PS case number 148/2024, already how many accused persons have been?
We have access to 4, my lord. All the FIR named accused persons, my lord.
All the FIR name accused persons have been,
as well as the proprietor of healthcare diagnosis.
as well as the proprietor of the healthcare diagnostics have been granted interim anticipatory bail by this court in different bail orders. Stop. Learned counsel for the petitioner has also submitted that the petitioners are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that the case diary may have to be perused for consideration of the instant bail application. Learned counsel for the petitioner has also submitted that the other connected cases are fixed on
4/10/2024.
4/10/2024 for case diary. Hence, let this case be also listed along with the other cases, namely AB case number 2309/ 2024 and AB case number 2365/2024 on 4/10/2024. However, considering the fact that the present petitioners are not named in the FIR and 4 of the co-accused are already given interim protection, the above named petitioners are directed to appear before the investigating officer of Dopoka PS case number 148/2024 within 10 days from the date of this order and cooperate in the investigation, if they do so within the stipulated period of time, in the event of their arrest in connection with Dopoka PS case number 148/2024. Both the above named petitioners shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount to the satisfaction of the arresting authority with following conditions. Condition number 1 and condition number 2. Let this case be listed again on 4/10/2024.
I'm deeply obliged.
Lord, your lordship may look at the order dated 29/8/2024.
Yes,
Lord, from 2 of the legal heirs, I am appearing. Out of 2, 1 has already expired and 2 is there. Now, the other side, I don't know why they're not present today. I think legal heir has been substituted. I do not know whether any judicial order is there.
it is not there. Legal heirs are substituted in the. Is there any interlocutory?
They filed an IA application.
Okay, that was allowed. Legal heirs of respondent number,
The sole respondent.
sole respondent have
Yes.
been substituted. You are appearing for both of them.
Both of them, that is Sulochana Devi, who expired in the meantime. Number 2, Mala Singh, she is there. In fact, now the case will proceed against Mala Singh again.
No, case will not proceed against Sulochana,
Sulochana is expired.
expired.
Right.
What is to be done now?
Lord, since the legal heir is already there, your lordship may fix a date for hearing after the vacation.
None appears for the applicant on call. Heard Mr. S. Dutta, London. Senior counsel assisted by Miss A. Bora, London counsel for the substituted respondents. On perusal of the records, it appears that by order dated 18/9/2019, passed in IA within bracket C 1402/2019, the legal heirs of the sole respondent who had passed away during the pendency of the appeal have already been substituted. Suit is stayed. Appeal is stayed.
Yes,
It is a no,
that was till the returnable date.
but
After they did not, possibly they
but
did
for
not.
last 10 years, it is
it is operating just
We
like.
will we'll give a fixed date for hearing.
Yes, yes.
Let this matter be listed for hearing on, when do you want?
My lord, anytime after vacation.
On,
May-
on 24th October,
Exactly, I wanted to say that.
24th October,
My-
2010.
Much obliged.
May I please, your lordship? My lord, in this matter, my lord, the petitioner challenging the imprint order 26/6/2024.
Why it has come up in orders column?
For consideration of interim, my lord, already this honorable court dated on 5/8/2024. And last posted on 12th September, it's considered that counsel representing the other side was not present. So today fixed for consideration of my interim prayer, my lord.
What is your interim prayer?
My interim prayer in this case, my lord.
May I submit, my lord, I am appearing for the opposite party. No question of interim order, my lord, your lordship.
It can be disposed of.
Yeah, very short matter, substitution only, my lord.
Today it can be disposed of.
Yes.
Okay, make your submission. Yes, what is the matter?
My lord, you'll find at least for the annexure 1. I'm the defendant, the plaintiff is a respondent here, my lord.
Which order you are impugning?
Lordship, page 43, that is 26 June 2024.
Yes.
Both sides are represented. The petitioners Anupama Das and Shubhendu Das had filed petition bearing number so under Order 1, Rule 10, order with section 151 CPC for impleading them in place of original plaintiff Sunil Das in the present case.
Just a minute, just a minute. Yes. Read again.
Yes, my lord. Both sides are represented. The petitioners Anupama Das and Shubhendu Das had filed a petition bearing number 106/7 under Order 1, Rule 10, read with section 151 CPC for impleading them in place of original plaintiff Sunil Das in the present case. The petitioners said
What happened to Sunil Das?
he expired during pendency of the matter.
No, who are Anupama Das and
They are the
Sven?
legal heirs of Sunil, wife and daughter. Well, son.
Okay. Thereafter, read.
The petitioner said pleaded at Anupama Das is the wife of original plaintiff Sunil Das, and Subhendu Das is the son of original
place of deceased plaintiff. Stop. Stop. Thereafter, it appears that by the impugn order dated 26/6/2024, the application of the respondents was allowed by the trial court, and both the respondents were allowed to be substituted as plaintiffs in place of their deceased, plaintiff, namely Sunil Das. Learned counsel for the petitioner has submitted that the trial court was wrong in allowing the petition, as the petition was not filed under proper provisions of law. The petition ought to have been filed under Order 22, Rule 3(1) of the Code of Criminal Procedure. However, the respondents had filed the petition under wrong provision. It is also submitted by learned counsel for the petitioner that the trial court was wrong in observing that, in spite of repeated opportunity given to the opposite parties, within bracket petitioner in this case, however, no objection was filed, no objection was filed, and neither the petitioners objected at the time of hearing. As the said observation is wrong, the learned counsel for the petitioner submits that the trial court made a wrong observation, as apparently on 9/7/2024, the petitioner had filed a written objection objecting to the impleadment of the respondents. He also submits that copy of the objection filed by the petitioner was also received by the counsel for the respondent side. He also submits that the petition for substitution was not filed within the period of limitation as prescribed under Article 20 of the 20 or 21?
120.
Article 120 of the Limitation Act, and there was a delay of
403 days.
403 days, and said aspect was not considered by the trial court. He submits that the suit of the plaintiff had already been abated, and there was no application for setting aside the abatement
Under Order 22.
in
Rule
this
9.
case. Stop. On the other hand, learned counsel for the respondents has submitted that wrong. Apparently, the application appears to have been application for substituting the legal heir of deceased plaintiff appears to have been filed under wrong provision. However, he also submits that when power to do a thing exists in a court, mere quoting wrong provision in the application would not invalidate the order passed by the trial court. He fairly submits that from record, it appears that the respondent has in fact filed a written objection against the petition filed by the not respond. He submits, he line to continue. He submits that from record, it appears that the present petitioner had in fact filed a written objection against the petition filed by the present respondents on 9/7/2024. And date is okay.
I think it is 16/8/2023.
But
16/8/2023. Objection.
but why this stamp is
27/1/22. Well, they have filed petition on 27 January 2023, page 30.
now when have you filed the objection?
We filed objection, my lord, on 16 August 23,
On 16/8/2023,
my lord.
which might have been overlooked by the trial court
Inadvertence.
due to due to inadvertence. Hence, he prays that the matter may be disposed of by giving a direction to the trial court to consider the objection filed by the petitioner afresh. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. Apparently, on perusal of the impugn order, no, for sake of convenience, the impugn order passed by the trial court on 26/6/2024 in Ms. J case number 144/2023 is quoted herein below. Court impugn order form, page 43. Apparently, on perusal of the above order, it appears that the petition filed by the respondents was allowed mainly on the ground that the present petitioner, mainly on the ground that the trial court was of the view that the present petitioner neither filed any objection nor objected to the petition filed by the respondents. Stop. No other reason has been mentioned in the impugn order for allowing the petition filed by the present petition, allowing the objection filed by the present petitioner. Sorry, no, allowing the petition filed by the respondents on 28, allowing the petition filed by the respondents. Stop. Which, stop. It also apparently appears that the trial court has overlooked the written objection filed by the present petitioner opposing the prayer for impleadment. The trial court has also not considered any of the grounds taken by the present petitioner opposing the petition for impleadment filed by the respondents. In view of above, this court is of considered opinion that the impugn order is not sustainable in law, and hence same is set aside. the trial court is directed to consider the application filed by the respondents on which date you have filed? Which was,
16/8/23.
filed by the respondent on,
16/8/23.
no, the petition,
Objection, my lord.
not petition, when the petition was filed. 27/6/23.
26. The petition filed by the present respondents, my lord.
Present
20
respondent,
27
27 January.
21/23.
What was the last name? Directed to consider the application which was filed by the present respondent on 27 January 2023. After taking into consideration the written objection filed by the present petitioner on 16/8/2023,
My lord.
and after giving an opportunity of hearing both the sides afresh.
Yes.
With above observation, this revision petition is hereby disposed of.
Deep look.
Obliged.
I have for direction, settlement of 50% awarded amount of this. Can be deposited, your lordship.
You have deposited.
No, we'll deposit it. He have filed the IA for a direction to deposit 50%. And our appeal is mainly on the quantum. So we can deposit it, your lordship.
Now, what is the status of the appeal?
Your lordship, the service has been complete. The necessary parties are here. It can go for hearing, your lordship.
You have no objection to
No.
deposit? Okay. Heard Mr.
Yeah, Muslim.
M. Hussain, learned counsel for the applicant. Also heard Mr.
H. Burago.
H. Buragohai, learned counsel for the respondent / insurance company. This interlocutory application has been filed by the applicant, praying for directing the appellant opposite party to deposit at least 50% of the awarded amount before the registry of this court during the pendency of the connected MAC appeal, that is MAC appeal number 532/2019. Stop. Learned counsel for the respondent insurance company has raised no objection to the same. Hence, this interlocutory application is disposed of with a direction to the opposite party insurance company to deposit 50% of the awarded amount, which was directed to be paid, directed to be paid by the insurance company by order dated or by judgment, which is impugned in the connected MAC appeal, that is judgment dated 24/4/2019, passed in MAC case number 217/2017 in 2017 by the learned member Motor Accident Claims Tribunal, Borpeta. This interlocutory application is accordingly disposed of.
After deposit lordship, that may be allowed to do by the.
Let them deposit, you file another I for withdrawal. You deposit within 4 weeks.
4 weeks.
Directed to deposit within 4 weeks of the date of this order. In main appeal, any order is required. service is not complete.
Lordship, the claimant is before this honorable court. The other parties are not necessary, your lordship. Their name may be struck off. Driver and owner.
This is an appeal for
Your lordship, we are challenging the quantum of the award.
only
your lordship.
quantum. Okay. Heard Mr. H. Buragohai, learned counsel for the appellant. Also heard Mr. M. Hussain, learned counsel, appearing for respondent number,
One lordship.
respondent number 1. Learned counsel for the appellant submits that the other respondents, namely respondent number 2 and 3, are not necessary for adjudication of this appeal, hence their name may be strike out. Stop, the prayer is allowed. Let the name of respondent number 2 and 3 be struck off from the cause title of the memo of appeal. Let whether the trial records have come, let the case record of MSC case number 217/2017 be called for from the concerned tribunal. Let this matter be listed after hearing, after receipt of the record of the from the concerned tribunal.
Obliged.
Item 6.
May I please, your lordship? Lordship, in this case, we have to await for service on all the respondent, all the opposite parties. Though there are reports regard to respondent number 2, but usual process report is not there. And 2 is the driver of the vehicle, so we can await for service because
Heard Mr. D. Mondal, learned counsel for the appellant, peruse the office note dated 11/9/2024, which shows that the notices sent to respondent number 2 registered posts with AD has returned with an endorsement within inverted comma, not found, comma, return to sender, stop inverted comma, close. Learned counsel for the appellant submits that the notices sent to the respondent number 2 through usual mode has not returned. Therefore, the service report may be awaited. Stop. As regards other respondents also, no service report has been received regarding the notices issued to them. Hence, await further. List this matter again after 4 weeks on a date to be fixed by registry.
obliged.
Item 7.
May it please your lordship? Your lordship may peruse office note dated 12/9/2024, your lordship. Here, your lordship, as regards respondent number 1, notice was received by her nephew.
By?
Her nephew.
Okay.
As regards respondent number 3, notices were duly served. But your lordship, respondent number 4 and 5, respondents could not be traced, your lordship, so services could not be served upon respondent number 4 and 5.
Who is respondent number 1?
Respondent number 1 is the claimant, your lordship. 1, 2, and 3 are claimants, your lordship. Respondent number 2 is the minor, and he was represented by respondent number 1.
Now, what is to be done?
Your lordship, we may be given some time to ascertain the correct addresses of respondent number 4 and 5, your lordship. They are necessary parties. They are the owner and driver of the vehicle in your advice.
Heard Miss P. Bothakur, learned counsel for the appellant. On perusal of the office note dated 12/9/2024, it appears that notices issued to respondent number 1 and 3 have returned after service. Stop. Therefore, the notices are deemed to be duly served on the said respondents. As regards respondent number 4 and 5, it appears that the respondents were not found, said respondents were not found in the address given in the notice. Stop. Learned counsel for the appellant has submitted that some time may be granted to the appellant for ascertaining the correct address of respondent number 4 and 5, as they are the necessary parties in this appeal. Stop. The prayer is allowed. Let this matter be listed after 4 weeks. In the meanwhile, the appellant shall ascertain the correct address of the respondent number 4 and 5 and let this court know about the same on the next date fix. List accordingly.
Obliged.
Hearing item number 8.
Lordship heard it long time back. I don't know if Lordship remembers.
I don't remember.
Yes.
Let me confess it.
Yes, Lordship. That's what,
When was it?
that's what I thought, Lordship. Because
When?
last evening when I was going through, I also had to recollect certain things. Lordship, last time I had given a written submission in page number 3, Lordship. One case was this Mahmood Ahmed, that was wrongly, his name was wrongly typed, Lordship. So I've got a new page type that I can't deliver. That Lordship had kept my written argument in the, I don't know, I didn't check in the morning whether it is there or not.
Written argument.
Huh?
Something. Written argument. What was the last date of hearing?
Lordship, actually it was last date, Lordship. Last date adjournment was taken by the
When was it heard?
last. Alida किती असेल last?
How much? 9 is the written argument.
3rd September.
Your written argument is not there.
39.
Oh. Lordship, then I have a copy, this 3rd page I just made. Can we make a copy here, Lordship, for 2 pages?
Yes.
I can give. এই দুখন এই প্রথম দুখন yeah. Oh, Lordship can take it up at 2. I'll get this one. These 2 pages because
the arguments, I am yet to do my argument. If she has completed her argument, then I can address your lordship.
no,
So
I
far,
not completed. That day it was not
so
completed.
let the argument begin and complete. Written submissions we can submit later.
Okay.
Again, taking it at 2 million, that will be.
No, because I mentioned certain pages here, Lordship.
No, what I propose, you argue your case. Both of you argue.
Yes.
And on 24th, you may submit a gist of arguments. On 24th, on Tuesday. Then we can, otherwise it will again remain part heard.
Yes.
That I don't want.
Even
On 24th, I'll fix it for submission of written gist. Both parties may submit brief gist instead of rushing now at 2 again.
Okay.
Yes.
No. Lordship,
Just,
First of all, what
Just-
I'm taking up is quantum. Lordship,
just-
I'll read the judgment that says,
just a minute.
yes, ma'am.
I might have taken note. Okay, start. I have,
Yes,
I have space for it. Yes.
Lordship, the
After the argument, you submit, both of you submit written gist. Yes.
Lordship, the judgment is at page 7, Lordship. In the memo of appeal, Lordship. It starts from 6.
Yes.
I'll read from. By the judgment, because Lordship, here my basically our appeal is based on 2 points, mainly quantum as well as gratuitous passenger, Lordship.
Okay.
Quantum as per the salary document and gratuitous passenger. Admittedly, they admitted gratuitous passenger. By the judgment, I intend to dispose of the petition filed by the claimant's mother and younger brother of the deceased under section 166 of the Motor Vehicle Act 1988 as amended up to date. Praying for award of compensation of a sum of rupees 1,07,86,756 for the death of one late Sabita Das, hereinafter referred to as the deceased, in a road traffic motor vehicle accident that had occurred on 29/7/2016 at about 2:50 p.m. at Kalinagar Part 8 under the jurisdiction of Panchagram PS in the district of Hailakandi. Case of the claimants in brief is that on 29/7/2016, the deceased was proceeding towards her residence from Silchar as a gratuitous passenger. Lordship will mark this gratuitous passenger. We are harping on that. Gratuitous passenger I is missing, Lordship, in the Maruti Alto 800 LXI bearing registration number so and so. That the vehicle was driven by its driver in a rash and negligent manner, for which when it reached Kalinagar Part 8 at about 2:50 p.m., it lost control and dashed against the backside of another stationary truck bearing registration number so and so. As a result, the deceased sustained grievous injuries on her person and was immediately taken to the Kalinagar PHC for medical examination and treatment, but the doctor declared her dead. In connection with the accidental death of the deceased, post-mortem examination on the dead body was conducted at the S.K. Roy Civil Hospital, and after completion of post-mortem examination, the dead body was taken to the house of the claimants and cremated as per religious rites. It is alleged that the accident took place due to rash and negligent driving by the driver of the offending vehicle. It is also averred that in respect of the road traffic motor vehicle accident, Panchagram PS registered a criminal case by Panchagram PS case number so-and-so under section so-and-so and investigated into the same. It is further averred that the deceased was 50 years old at the time of death and used to earn a salary of rupees 41,749. Lordship will mark this salary here per month, being an assistant teacher of Siddheswar Higher Secondary School. It is also averred that the deceased was the sole earning member of the family and the claimants were solely dependent upon the income of the deceased. It is furthermore case of the claimants that due to her untimely death, they are suffering from acute financial hardship. Hence, the claimants have come up with a claim petition before this tribunal seeking compensation of a sum of rupees 1,07,86,756. In pursuance of the claim petition, notice was served upon the OPs. On receipt of notice, the OP number 2 National Insurance Company Limited appeared and filed its written objection denying the mode and manner of the accident as alleged in the claim petition. The insurance company also took defense under section 147, 149 to 170 of the Motor Vehicle Act. The insurance company further pleaded that the amount of compensation claimed is excessive, inflated and without any basis, and the claimants is not entitled to any such compensation. However, the OP number 1 owner did not contest the case. The owner did not appear, Lordship. From the pleadings of the parties, following issues were framed. Whether Sabita Das, the deceased, died as a result of motor vehicle accident occurred on so-and-so at about 2:50 p.m. at Kalinagar, Part 8, under the jurisdiction of Panchagram PS. Whether the accident occurred due to rash and negligent driving of the driver of the offending alto bearing registration number so-and-so. Whether the claimants are entitled to any compensation. If so, what is the just and reasonable, and to what other relief the claimants are entitled, by whom amongst the OPs the same is payable, discussion, decision, and reason thereof. In order to prove the issues, claimant number 2, Srimati Sulekha Das, being mother of the deceased, tendered her evidence by way of affidavit as PW1 and marked several documents from Exhibit 1 to Exhibit 27 and Annexa 1. It may be noted here that during pendency of the claim petition, the claimant number 1 expired and his name was struck off from the claim petition. Brother of the deceased, that is claimant number 3, also adduced evidence as PW2 and marked documents as Exhibit 28 and Exhibit 29. Claimant side also examined Senior Assistant Jagadish Chandra Dev of the Office of the Inspector of Schools, CDC, Silchar, as PW3. Lordship, this evidence also, I would like to argue on this evidence also, who also marked documents from Exhibit 30 to Exhibit 32. Evidence of PWs been subjected to cross-examination. The OP number 2, answering insurance company, took full scope to cross-examine all the witnesses. Upon closure of evidence of the claimant side, the answering insurance company did not adduce any defensive witness. Upon closure of evidence stage of both the sides, I have heard arguments advanced by the learned counsel for both the sides. I have also perused the evidence on record in its entirety. For the sake of brevity and convenience of discussion and decisions, the issues are taken up together without following the serial number of the issues. The findings on the specific issues are as under. It is the case of the claimants that the deceased died in a road traffic motor vehicle accident arising out of rash and negligent driving of a motor vehicle owned by OP number 1, driven by a driver who also died in the same accident and insured with the OP number 2. The claimant preferred the claim petition under the provision of MB Act. An allegation of rash and negligent driving attributed to the driver goes to show that the claim application had been filed under Section 166 MB Act. Hence, it is incumbent upon the claimants to prove that the deceased died in a road traffic motor vehicle accident caused due to rash and negligent driving by the driver of the offending vehicle. To determine the negligence of the driver of the offending vehicle, it has been held in National Insurance Company Limited versus Pushpa Rana and another, reported in 2009 Accident Claim Journal 287 as follows. Lordship, we are basically not on the accident, we are not denying, so I'll skip this paragraph, Lordship. 8. It is an established principle of law that in a claim petition under the Motor Vehicle Act, the standard of proof to establish rash and negligent driving by the driver of the offending vehicle is not at par with the criminal case, where such rash and negligence is required to be proved beyond all shadow of reasonable doubt. In Kusuma Begum and others versus New India Assurance Company Limited, reported in so-and-so, it was inter alia held by the Honorable Supreme Court that the issue of wrongful act or omission on the part of the driver of the motor vehicle involved in the accident has been left to a secondary importance, and mere use or involvement of motor vehicle in causing bodily injury or death to a human being or damage to property would make the petition maintainable under Section 166 and 140 of the Motor Vehicle Act. In the present claim petition, the case of the claimants is that on 29/7/2016, the deceased was proceeding towards her residence from Silchar as a gratuitous passenger. Lordship, I'll again like to reiterate this word here mentioned by the tribunal. Gratuitous passenger in the Maruti Alto 800 LXI bearing registration number so-and-so. That the vehicle was driven in a rash and negligent manner, for which when it reached Kalinagar Part 8 at about 2:50 p.m., the driver lost control and dashed against the backside of another stationary truck bearing registration number so-and-so. As a result, the deceased sustained grievous injuries on her person and was immediately taken to the local Kalinagar PHC for medical examination and treatment, but the doctor declared her dead. In connection with the accidental death of the deceased, post-mortem examination on the dead body was conducted at the SK Roy Civil Hospital, and after completion of post-mortem examination, the dead body was taken to the house of the claimants and cremated as per religious rites. To prove death of the deceased arising out of the rash and negligent driving by the driver of the offending vehicle, the PW1 produced certified copies of the criminal case registered against the driver of the offending vehicle bearing registration number so and so. On perusal of the accident information report in Form 54, FIR and police report under Section 73 CRPC marked as Exhibit 1 to Exhibit 3, claim of the claimants is found corroborated, which fortifies the fact that on the aforesaid date, time, and place of occurrence, the accident occurred, and in respect of the accident, a regular PS case number so and so under section so and so was registered at Panchagram police station, in which the investigating police officer, after completion of investigation, submitted final report under section 73 CRPC, holding that the case was found truly established against the accused driver Pratyush Chakraborty, who died in the accident of the Alto car bearing registration number so and so under section so and so. The seizure list marked as Exhibit 4 to Exhibit 8 speak that in connection with the accident, both the vehicles, that is the Alto vehicle and the involved stationary truck, were seized. The MBI report of the Alto car by Exhibit 9 speaks that the front side of the Alto car was damaged. Hence, the case of the claimant that the Alto car dashed the stationary truck from behind stands established. The postmortem report marked as Exhibit 12 transpies the fact that the postmortem examination of the dead body of the deceased was conducted on 29/7/16 at about 5:30 p.m. and the forensic surgeon opined that death was caused due to hemorrhage and neurogenic shock following grievous head injury sustained. Therefore, the postmortem report lends corroboration to the claim of the claimants that the deceased died as a result of the motor vehicle accident occurred on 29/7/2016 at about 2:50 p.m. under the jurisdiction of Panchagram PS. The answering insurance company, though, cross-examined the PW1, but it failed to controvert the evidence of the PW1, coupled with documentary proofs to negate the fact of accident arising out of rash and negligent driving of the driver of the Alto vehicle, resulting in death of the deceased. Since claimant's side discharged its burden of proof with the help of police papers that accident occurred due to rash and negligent driving of the driving by the driver of the Alto vehicle, it is duty of the insurance company or the owner of the vehicle to establish that the accident did not occur due to rash and negligent driving of the offending vehicle. But the answering of insurance company did not discharge its burden and the owner did not participate in the hearing. Police investigated the case, and in spite of the fact the prima facie case was found well established against him under the aforesaid section of law, submitted final report under section 173 CRPC as because the accused driver also died in the accident. So relying upon the testimonies of the PW1 as well as relying upon the exhibited document, the issue number 1 to 2 are decided in favor of the claimants, holding that the deceased died as a result of motor vehicle accident occurred on 29/7/2016 under the jurisdiction of Panchagram police station due to rash and negligent driving by the driver of the offending Alto car bearing registration number so and so. In view of affirmative decision of issue number 1 and 2, the claimants are found entitled to compensation. However, question remains regarding quantum of compensation that has to be awarded. Since this is a case of death, the age, income, occupation of the deceased and number of dependents needs to be considered. According to the claimants, the deceased late Sabita Das was aged about 50 years at the time of her death. In the evidence on record, I have found service book of the deceased marked as Exhibit 31. Since deceased was a government servant, I find the service book more reliable to determine the age of the deceased. As per service book, date of birth of deceased was 3/1/1966. Deceased died on 29/7/2016, and in that count, deceased was 50 years, 6 months old at the time of her death. Hence, in view of the ratio laid down in Sarla Verma and others versus Delhi Transport Corporation and others, the proper multiplier to the age group of person belonging to 46 to 50 years is 13. Learned counsel for the insurance company argued that since the deceased was 50 years, 6 months old, multiplier 11 of the group for 51 to 55 years should be selected. But learned counsel for the claimant relied on Shashikala and others versus Ganga Lakshmana and others, so and so, wherein applicability of multiplier of 14 while computing amount of compensation for the deceased in a motor vehicle accident who was 45 years, 5 months and 28 days old was held as justified. Observation of the Honorable Apex Court is in above referred case are reproduced as follows. Insofar as appropriate multiplier, the date of birth of the deceased as per driving license was 16/6/1961. On the date of accident, that is 14/12/2006, the deceased was aged 45 years, 5 months and 28 days, and the tribunal has taken the age as 46 years. Since the deceased has completed only 45 years, the High Court had rightly taken the age of the deceased as 45 years and adopted multiplier 14, which is the appropriate multiplier, and the same is maintained. Total loss of dependency is calculated as so and so. In the instant case, since deceased did not complete the age of 51 years, selection of multiplier 11 does not arise. Otherwise, the intention of the Supreme Court in formulation of multiplier table with indication of exact age group will be interfered. Hence, this court has selected the multiplier 13. Claimant Srimati Sulekha Das is the mother of the deceased, and claimant Sri Ravi Shankar Das is the brother of the deceased, who has already attained majority and has his own wife and children. Ravi Shankar Das deposed as PW2 that the deceased was married to one Pijus Kanti Das on 30/1/1997, and within 1 month of her marriage, she left her husband's house and started staying with the claimants, and their marriage was dissolved by a decree of divorce dated 2011-98. In this case, it is admitted that deceased was a divorcee and was staying with the claimants after separation from her husband. In view of next of kin certificate issued by Deputy Commissioner Kachar marked as Exhibit 29, claimants are the next of kin of the deceased. The PW2 also during cross-examination deposed that his mother Sulekha Das is entitled to pension of his deceased sister, that till date they have received an amount of rupees 5 lakhs to rupees 6 lakhs as service benefits of deceased, and the pension is under process. The PW2, however, deposed during cross-examination disclosed that he uses to maintain his own family consisting of his wife and daughter. Since Ravi Shankar Das PW2 is a married man and he uses to maintain his own family, this court sees no reason to consider him as dependent upon the income of his deceased elder sister. However, the argument advanced by the learned counsel for the insurance company that mother of the deceased is also not dependent upon income of the deceased holds no water, as because she is entitled to pension of the deceased as per the deposition of PW2 during cross-examination. Moreover, dependency of PW1 remained unchallenged during her cross-examination. Moreover, deceased was a divorcee and had no children. Therefore, mother of the deceased is considered as dependent upon the income of the deceased. Hence, it is concluded that there is one dependent of the deceased. Learned counsel for the insurance company argued that deduction should be 50% as because the deceased being a divorcee, her status is like a bachelor maiden. As per Sarla Verma case, even if the deceased is survived by parents and siblings, only the mother would be considered to be a dependent, and 50% would be treated as the personal and living expenses of the bachelor, and 50% as the contribution to the family. In this case, the deceased was divorced, and therefore, as argued by learned counsel for the insurance company, status of the deceased is like a bachelor. No claimant would admit that the deceased was a spendthrift, even if she was one. It is also very difficult for the insurance company in a claim petition to produce evidence to show that the deceased was spending a considerable part of the income on herself, or that she was contributing only a small part of the income for her family. Therefore, this court finds it reasonable and safe to stick to deduction of 50% towards personal expenses of the deceased, as observed by Honorable Supreme Court in Sarla Verma case Supra. As per the position of PW3, an official from the Office of the Inspector of Schools, and as per service book and last pay certificate marked as Exhibit 31 and Exhibit 32, respectively, the deceased was an assistant teacher in Siddheswar HS School, and her last gross pay was rupees 51,364. And after deduction, this lordship, again, this I'll stop, lordship.
No, you finish the judgment, then I'll
Yes,
take that.
lordship. Fine, lordship. This lordship again I would like to mark, and after deduction of personal taxes and GIS, her net salary was rupees 50,956. It is seen that an amount of rupees 208 was deducted towards personal tax and rupees 200 towards GIS. Following decision of our apex court in National Insurance Limited versus Indira Srivastav and so and so and so, I am of the opinion that deduction towards other heads are not liable to be deducted from gross monthly salary to assess compensation except the professional tax and income tax. After deduction of professional tax of rupees 208 from gross monthly salary of rupees 51,364, monthly salary of deceased stands at rupees 51,364 minus 20 so and so. No income tax related document found exhibited in record except for the previous years. The documents available on record do not reveal the deduction of income tax recording the monthly income of rupees 51,156. Therefore, this court deducted the income tax as follow, as below. So and so the calculation is made, Lordship, income tax of 10% deducted. Hence, total income tax payable is rupees 36,387 plus 1091. This is after deduction of income tax, I found the annual income is rupees 6,13,872 minus so and so. So this is the calculation, Lordship. As per the decision of our apex court in National Insurance Company Pranay reported in so and so, related in Lovely Devi so and so, we are to add 15% of the annual loss of dependency, that is rupees 43,230 as future prospects since deceased fell into the age group of 50 to 60 years and was in a permanent government job. To find out the total loss of dependency, we are to multiply the sum iman with 13. So the court came to the conclusion that the dependency stands at rupees 43,08,551. As per the decision in the Honorable Apex Court in National Pranay City, again 15,000 added for funeral and loss of estate, Lordship. After that, the court came to the conclusion that 43,38,551 is the amount. The accident took place due to rash and negligent driving by the driver of the offending vehicle owned by OP number 1 and insured with OP number 2 National Insurance Company Limited. There is no dispute that the offending vehicle was covered by a policy of insurance, which was a package policy. Lordship, I would like this to be marked.
Which?
This paragraph 16, Lordship. In that, the court is taking note of the policy, Lordship.
Okay.
That it is not disputed. Policy was not disputed by the claimants, by the insurance company. No one disputed that.
Which was a package policy.
Package policy. And then the court came to this Balakrishnan judgment. I'll read, Lordship, which will be vital when I give my reply
Okay.
to their.
I'll take one short break.
No, you should not.
Yes.
I'll start from 16, Lordship.
Yes, 16.
Yes.
The accident.
The accident took place due to rash and negligent driving by the driver of the offending vehicle owned by OP number 1 and insured with the OP number 2 National Insurance Company Limited. There is no dispute that the offending vehicle was covered by a policy of insurance, which was a package policy. Admittedly, the vehicle was a private car. Lordship, this private car also, I would like to mark. Regarding occupant in a private car, Honorable Supreme Court in National Insurance Company versus Balakrishnan and another reported in 2012 so and so observed. In view of the aforesaid factual position, there is no scintilla of doubt that a comprehensive package policy would cover the liability of the insurer for payment of compensation for the occupants in a car. There is no cavil that an act policy stands on a different footing from a comprehensive package policy. As the circulars have made the position very clear that the IRDA, which is presently the statutory authority, has commanded the insurance companies, stating that a comprehensive package policy covers the liability, there cannot be any dispute in that regard. We may hasten to clarify that the earlier pronouncements were rendered in respect of the Act policy, which admittedly cannot cover a third-party risk of an occupant in a car. But if the policy is a comprehensive package policy, the liability would be covered. These aspects were not noticed in the case of Bhagya Lakshmi Supra, and therefore the matter was referred to a larger bench. We are disposed to think that there is no necessity to refer the present matter to a larger bench, as the IRDA, which is presently the statutory authority, has clarified the position by issuing circular, which have been reproduced in the judgment by the Delhi High Court, as we have also reproduced the same. Lordship, here Bhagya Lakshmi case, Lordship, I would like to mention about this is 2012, passed in 2012. Hence, in this case, as the vehicle was insured under a package policy, the risk of the deceased being an occupant is covered. Therefore, the insurance company is liable to pay compensation in this case. Hence, issue number 4 is decided accordingly, holding that the full amount of compensation is to be paid by the OP number 2 National Insurance Company. Learned counsel for the insurance company contended that interest shall not be paid at the rate more than 6% per annum and relied upon the decision of Honorable Apex Court in the case of so and so. On the other hand, the learned advocate for claimant submitted that the interest rate shall be paid at the rate of 9% per annum with effect from the date of filing of the claim petition, and he relied on the decision of our High Court in Sabir Sheikh. I have gone through the cited judgment here in above referred to by the rival parties and found that the judgment of Honorable Apex Court is more relevant in the present context, as the Honorable Apex Court exclusively dealt with provision of Section 171 MV Act, which deals with aspect of rate of interest to be awarded in claim cases. So relying upon the decision of the Honorable Apex Court, I am of the judicious view that prevailing interest rate of 7% per annum will meet the ends of justice. Therefore, in view of the decisions arrived at of the issues, the claimant is entitled to compensation of rupees so and so 43,38,551, and the OP2 National Insurance is directed to deposit the amount compensation 30 days from today, along with interest 7% per annum with effect from the date of filing of the claim petition, that is a month till realization in full. So that is the judgment. Lordship, first of all, let's come to the quantum. That day also I argued on that, Lordship. Lordship, exhibit 16 in the LCR, that is at page 58, Lordship, of LCR.
Page 16 is an application.
No, exhibit 16,
Oh,
page
it's-
58.
Okay, okay. Yes, exhibit 16.
Page
What
58,
is
Lordship
this?
got it. It is a salary.
Yes.
Salary certificate, Lordship, which is of 41,748. This was exhibited by the claimant side themselves. And this date, Lordship, will mark, it is dated 26/8/2016. This is after the death.
When he died?
29/7.
When the accident occurred?
29/7/2016.
Okay.
She died, Lordship.
Yes.
She was a
lady.
lady, Lordship. And this was issued on 26/8/2016, Lordship. Then, Lordship, the next exhibit, exhibit 17, page 59, the next page itself, Lordship. This is also a salary certificate of the same person. Here they show the salary to be rupees 52,364. And this is issued in 2018, Lordship. Then Lordship will peruse the evidence of PW1. In exhibit 19, Lordship, total salary for assessment year 2014-15 was, that is the income tax document they have exhibited, Lordship, exhibit 19.
Yes.
Total income here was lordship 4,12,512. So if we divide that lordship, monthly salary comes to rupees 34,376.
4 lakh.
12,512.
And monthly salary comes to?
If we divide that with 12 lordship, it will come to 34,376.
Okay.
Then again, lordship, as per evidence of PW1, page 25 LCR, in exhibit 20, total salary for assessment year 2015-16 was 4,48,168.
Exhibit
20 lordship. This is also income tax return lordship.
Exhibit 20, the total salary was 4 lakh.
4,48,168
What comes?
to 37,347 monthly comes to that. But another important aspect in this document, which they exhibited lordship as income tax return, the gross salary is not mentioned in this exhibit. There's no mention up on the upper part lordship.
Yes.
And lordship, no income tax return for the assessment year 2016-17 was submitted before the tribunal, though the deceased died on 29/7/2016. After the date of filing of the return.
Okay.
Because the returns are filed in March lordship. Now the thing has changed, but in 16-17, that the system we used to follow was in March, we have to file the taxes. And she died on 29/7 in the month of July. They did not submit any income tax return because it will be revealed that their claim of 41,749 or 52,364 is not true. And the person who proved this rupees 52,364 lordship, that also I'll come to, because I talked while reading the judgment, I talked about PW3 lordship. For his evidence, his exhibits were under objection. I'll come to that lordship. In exhibit 32, page 101 of the LCR lordship. Last time also I showed it. The amount is overwritten. And lordship had said ki it is 1 and 2, that is, but the thing is why I'm saying why I'm showing lordship.
What is overwritten?
That
51.
5-1
Okay.
and 5-2 lordship. Why I'm showing all these discrepancies lordship, because the salary that they tried to prove at 52,364 was in fact not the salary. They are giving themselves, they are giving different salaries of the deceased lordship. Their own documents are revealing about. Then lordship will peruse the evidence of PW3 who proved the salary. That page number I have not mentioned here. He says revised scale of 46,310 came into effect on 1/4/16, and after one increment, the scale was 47,700 on 1/7/16. In his evidence lordship, he stated this. But whereas lordship, if this was the position lordship, that 1/4/16, the amount was 46,310, and from 1/7/16, it was 47,700. Then lordship, exhibit 16, which was dated 26/8/2016, lordship, after this, exhibit 16 is in the month of August, and and he is talking about month of July, 1/7/2016. Then that day, that time only it was 47,700. Then why exhibit 16 is mentioning about 41,749, Lordship? And in his cross-examination, now Lordship, if takes up the cross-examination, I won't go through the whole thing. I'll just mention in the end, Lordship. All the exhibits are under objection by insurance company on the ground that these are Xerox copies. Net taxable income rupees so and so. I have no knowledge regarding the exhibits. The revise was effected on 1/4/2016. He has no knowledge. He was the official according to the claimants and the judgment also, Lordship. The learned tribunal held that he is the official witness. He came with the salary and service document, and he says that he doesn't have any knowledge regarding the exhibits, and also all these are Xerox copies, and the advocate for the insurance company had objected to that. So, Lordship, my first judgment will be
No, before that, what is your submission that this is not admissible? That is your submission.
yes, because
Xerox copy.
they are giving different amounts, Lordship.
So it is not believable.
It is not believable. If they want to that it should be suppose, Lordship, this person was working. We are not denying that.
What salary was taken by the
52,000.
by the tribunal?
52,000, the highest one, Lordship.
52,364.
Gross pay was 51,364.
51. That is exhibit 32.
Hmm.
Where there is a correction.
Correction.
Okay.
The highest one the court took, but they have given the two different kind of salary certificates, Lordship.
No. What is the submission? Why that exhibit should not be believed?
It should not be believed because it is contradictory to the other salary certificate. Same salary certificate, Lordship. 16 is also a salary certificate. And that docket 32 is also a salary certificate. 1 point. Lordship, the income tax returns that they have submitted, those also, they give different kind of salary. They do not mention, there is nothing to show that she was earning 50 something, Lordship. If at all they want to correct it, it has to be remanded back and they have to bring in the correct salary, Lordship. It has to be truthful. So this total, I am challenging this calculation of the compensation based on this kind of different salaries. I'm challenging that, Lordship. That is my submission. That the calculation made by the court is totally wrong because the court had all these documents. The court should have questioned. It is an inquiry court. The court should have questioned why this kind of, the court has not. Court has directly gone to 32 and accepted it as the gospel truth, Lordship. Whereas all these documents, and whereas the person who came to prove 32, Lordship, in his cross-examination, what he is saying is that I have no full knowledge regarding the exhibits. So how that document could have been accepted by the tribunal, Lordship?
So what should have been the correct computation according to you? There is no material.
There is no material. How can I say, Lordship? I find that 41,000, 51,000, then 37,000, 34,000 from the document. There is no material.
There are materials.
But they are all contradictory to each other. There is too much of material, maybe, Lordship. Had they proved one salary certificate, it would have been easier for me also to show that, okay, this is the amount. But Lordship, there is too much of salary certificate and the amount that is taken from the document, it is overwritten, Lordship. And in that overwritten document also, it is not, her gross salary is also not mentioned.
Okay.
So, this salary, Lordship, on quantum salaries, certificates, not certificate, certificates that they prove. And the income tax return on the in the year she died, they have not given any income tax return on that day, in that year. Though she died in July and the return is to be filed in March, Lordship. Why? And this 32, Lordship, it comes when? In 2018, it is of a later date, not of immediately after the accident. And the person who came to prove it, he doesn't have any knowledge regarding these exhibits, Lordship. So how can that be believed, Lordship?
Who is PW3?
He's the official witness, Lordship, who came from the office of
School.
Came from the, it's mentioned in the judgment. I'm not going evidence or file to Rihanna.
Senior Assistant Inspectors of Schools.
Yes, Lordship.
CDC. CDC means Rachar District Circle.
I don't know much.
Exhibit 32,
Yes, Lordship.
which mentions is in original. It is not photocopy. It was proved in original. As per the Exhibit 17. Exhibit 32 and Exhibit 30, Exhibit 17 are the same documents. Last Exhibit 17 and Exhibit 32
Yes,
are
page
the,
15. Yes,
are the same document.
yes.
One is original, one is photocopy.
And
So
exhibit
why
17, Lordship, exhibit 17 was exhibited by the claimant herself, the mother of the deceased.
Yes.
She herself exhibited exhibit 16 also.
And
32 was done by that official witness. Lordship.
it was compared with original.
Compared with original, that I do not know, Lordship, seal when it was put. But thing is, whatever I found in the cross-examination, Lordship, I'm showing that the advocate put an objection to all the exhibits because they are photocopies. Had that been so, the court would have said that it is, the court would have mentioned that it is proved in original. But in cross-examination, that has come, Lordship.
Now, what has come in cross-examination? Please read.
All the exhibits are under objection by insurance company on the ground that these are Xerox copies. Thereafter, I've given daughter net taxable income, rupees 26 something. I have no knowledge regarding the exhibits. In chief, the witnesses can say something. They are their evidence is broken in cross-examination, Lordship. If he has come to adduce evidence to prove a document and in cross-examination he says
What it means, I have no full knowledge. He may not be having personal knowledge. It only means that
I
he
have-
is exhibiting the original document. He is an official of the Office of the Inspector of Schools.
Yes, but in his chief lordship, he's saying many things.
No, relevant portion is Exhibit 32 is the last pay certificate of the deceased for the month of July, which is in original. Original copy, original again copy of Exhibit 17. So it appears that he produced the original of Exhibit 17 in the court, on which court relied.
And 16 lordship, then?
16 is a different document.
And also the income tax returns lordship, they were also exhibited.
So your submission is when three different documents are showing three different annual salary.
How can any one of them be? Why not 16 lordship?
Yes.
Why the court has to believe only on 17 or
Yes.
30?
Now what is your submission? What court should have done?
The court should have
Not
asked
to
for
rely.
the best evidence lordship that you prove
So
it.
court has picked up the best evidence, the highest salary.
The best evidence against the
Highest salary.
highest salary. That is not
How?
the best evidence lordship.
No, how court was wrong in that?
Court
What is your submission?
That is my submission, lordship. When there were, in fact, the income tax return, if we take all of them, lordship, then it comes to 4 documents.
Yes.
4
Which
documents.
gives different salaries.
Salaries.
Different
Amount of salary.
salary.
And lordship will, that I'm also, that's why I mentioned about the date, lordship. Exhibit 16 is dated 26/8/2016. And the deceased had that was just within a month of her death, lordship. She died on 29/7/16, lordship, 26/8. So within that month, her salary was 41,749. And when after 2 years, that is on 21/2/18, lordship, that is exhibit 17 and exhibit 32, lordship, it increases, the salary increases. And the corresponding documents that are the income tax returns, lordship, those are also not tallying with the income.
Okay. Okay.
I have created a doubt, lordship. And there also, before the tribunal also, the dealing council had created that, but the court has just brushed it aside. And when
Court has not, you have created a doubt and court has picked one of the,
how can the court pick one of them?
that is your submission.
Yes,
That
how
court
can the court do that?
was wrong.
Yes, court is not supposed to do that.
What it should have done? What is your submission that I want?
That lordship, if we go by that lordship, Sarla Verma, then they, in fact, if we come to the bottom line, there is nothing to laugh about it. If we come to the bottom line, lordship, occupation and income remain not proved. That is what I have written in my argument also.
That is your line of submission.
Yes.
Okay.
Occupation and income remain not proved because the documents they are showing are totally contradictory. So how can we believe? And the court doesn't have the right to pick and choose, lordship. Does the court has that right been given to the tribunals to pick and choose whatever is they think is best? So, lordship, I'm also relying upon Sarla Verma. Oh, before that, lordship, photocopies of the documents, our High Court judgment, Partha Pratim Roy, I'm submitting that to show that as per section 62 and 63, admission of photocopies is not. Then, lordship, I'm relying.
Pratim Roy.
Yes. I'll give all the judgments, lordship, I've brought.
You mentioned, mark the paragraph also.
Yes.
In the top page, you can write about the paragraph number.
14, I've marked it this way. Is it okay, lordship?
Okay.
Paragraph 14. No, it is another. I'll give together or
Along with your written.
Okay, on 24th.
on 24th.
No issue. Then I'm also relying based on this because I'm on quantum, Sarla Verma. Sarla Verma, it is clearly, yes, I don't want to show it again and again that the claimants have to establish and also pronicity. Establish the income and
What is
occupation.
the language used?
Establish in pronicity.
Read it.
Pronicity to unable to connect. I'll read it. I thought pronicity everyone knows.
No, even if we know, we can read it again and again.
Okay. That is good for me also.
That relevant portion on which you are relying.
Yes, that establish the income and occupation. Plus pronicity to every.
Or you may include it in your in written submission.
Yes, I have done that.
Okay.
I've done that. It is their lordship. I know it very well that the established income is to be taken. The occupation and income is to be established. That is there. I'll mark it. Then again, one of my argument is that the case was filed in the year 2019. Sorry, 2017. The judgment was passed in 19, so they delayed the disposal. My lord might not agree with that, but I have made that here that the
You are yourself doubtful.
yes, lordship, because but then I'm submitting that interest ought to be from the date of adducing evidence, lordship. And third is lordship that on the quantum itself, that interest on future prospect is granted. Our High Court many a times, many judgments are there. I'm giving one judgment, lordship. So that interest on future prospect is not to be given. Because lordship, future prospect income is of a future date. Why should the insurance company pay that future prospect interest, which comes at a later time? Then lordship,
Which judgment you are relying for future?
lordship, MSc Appeal 96 of 2009. This was the first. Thereafter, Justice that is lordship MSc Appeal 96 of 2009. Oriental Insurance versus Sulochana Devi Kayal. And thereafter also judgments came, lordship. Justice Michael and Justice Silo also passed certain judgments on that. The future prospect interest should not be. Then lordship, I come to the gratuitous passenger part. Lordship, in the claim petition, in the judgment, everywhere from the very beginning, it is mentioned that the deceased was a gratuitous passenger.
Yes.
I'm giving first Tilak Singh case, lordship. In Tilak Singh case, it was observed at para 16, lordship. In our view, the observation made in Asha Rani's case, Supra, were in connection with carrying passengers in goods vehicle, The same would apply with equal force to gratuitous passengers in any other vehicle also. Thus, we must hold the contention of the appellant insurance company that it owned no liability towards the injuries suffered by the deceased Rajinder Singh, who was a pillion rider, as the insurance policy was a statutory policy, and hence it did not cover the risk of death or bodily injury to gratuitous passenger.
No, but in this case, the insurance policy was a statutory, but in your case, it is a package policy.
I'll come to that, Lordship. Next judgment is on that. This judgment I'm showing, Lordship, because Asha Rani, earlier what happened? All the gratuitous passengers only were
Goods.
a goods vehicle were considered as gratuitous passenger. But here the change came that
In
even in private
private
cars,
vehicle.
there can be gratuitous passenger, Lordship.
Mm.
Then I come to this Manwara Khatun case. Lordship. Manwara. Lordship, this will be 2017 4 SCC 796. Manwara Khatun and others versus Rajesh Kumar Singh, and 2 judgments were given. This has gone from our High Court, Lordship. And Mamuni Sarkia Mohanty and others versus Rajesh Kumar Singh.
What it says?
Lordship, first of all, that about the private vehicle, paragraph 6, Lordship, the tribunal held that Tata Sumo was a private car driven by the driver in a rash and negligent manner at high speed. Private car, package policy. Then, Lordship, paragraph 18. The facts of the case at hand are somewhat identical to the facts of the case mentioned supra, because here also we find that the deceased were found traveling as gratuitous passenger in the offending vehicle. And it was for this reason the insurance companies were exonerated. In Sanju P. Paul's case, supra, also having held that the victim was gratuitous passenger, this court issued direction against the insurer of the offending vehicle at first satisfy the award sum and then recover the same from the insured in the same proceeding. The law laid here was that we have to give the claimant and then recover it from the owner of the vehicle.
No, what policy was there in those cases?
Gratuitous policy in private car, Lordship, Tata Sumo. That is why I read.
No. It only speaks about the nature of vehicle, whether it was a goods vehicle or private vehicle. But what about the policy? In this case, the policy was a package policy.
Package policy.
In the case which you are citing, whether the policy was a package policy or a statutory policy.
That is not, I did not find it, Lordship, but still I'll again go through the judgment and.
Okay, then we have to hear the other side. What is their stand?
Yes,
Oh.
fine, Lordship, on that point, no issue. And that policy, Lordship, I had filed that order 41 petition, Lordship dismissed it, saying that already we have given evidence
Okay.
to prove the policy, because in the policy coverage of 1 lakh of rupees was there. Because what our contention is that we are not liable totally. And though in this case, it is shown that the court has asked Manwara Khatun that pay and recover. I'll now again go by some other judgments, Lordship, which shows that only Apex Court can direct under Article 142 to pay and recover. Tribunal and High Court does not have that right, Lordship. That is what I'm going to show now. Though this judgment, I should, because gratuitous passenger, Lordship, I'm harping in this judgment about the gratuitous passenger. Claim petition, judgment, everywhere it is mentioned about gratuitous passenger. And policy, Lordship, though Lordship has dismissed our IA, Lordship, but fact remains that the tribunal also relied on the policy, and there is no why, when should one prove a policy? Even if Lordship has dismissed our IA, when should a document be proved? If it is denied, Lordship, if it is not denied, are they denying that there was a policy? If they deny it, then we do not have any liability. Nobody is denying. The court has also mentioned, tribunal has also mentioned that policy is not denied and that it is a package policy. That is also not denied. And in that policy, Lordship, I have also annexed with my memo of appeal, Lordship has mentioned that Lordship may look in the.
You can go through the.
Yes. And in that 1 lakh of rupees for 5 passengers, premium for 5 passengers covering 1 lakh of rupees was paid in the policy. So that may be our liability ultimately, if at all we are liable. So this judgment, Lordship, then I come to Rajni Devi Lordship, Rajni Devi judgment Lordship, that paragraph 6 Lordship. Rajni Devi.
But you have not shown any specific judgment which lays down the law that in case of package policy, also even in case of package policy, gratuitous passengers are not covered.
Manwara Khatun, because Tata Sumo, gratuitous passengers, they.
No, that speaks about vehicle only. Manwara Khatun speaks about the
Vehicle being Tata Sumo, but private car.
maybe, but what was the policy? It was the
There was no policy Lordship, the court could
no
not have
whether the
directed.
policy was act only policy or the
No, if act only policy, it is clear, Tilak Singh, that's why I showed Tilak Singh Lordship. If it is act only policy, insurance company is totally not liable. There is no question of pay and recovery or anything. If it is package policy, then only, and
No,
if they are gratuitous
my
passengers.
query, I have not gone through the judgment.
Yes.
In Manwara Khatun's case, what policy was there? Package policy.
No, Lordship, package policy, that
Then only it will be applicable to this case.
I'll have to again read Lordship to find that package word, package policy.
You do it while you submit your written argument. Address that issue in your written argument.
Yes. Because this Lordship, I found that they were traveling in Tata Sumo was a private car driven by the driver
That I have
and gratuitous.
that I have understood what you want to convey. That private car, gratuitous passengers were not allowed any compensation. But you have not stated that what policy was there.
Lordship, Tilak Singh case, Lordship, Tilak Singh is on that, Lordship, that it will be contingent that it was no liability towards the injury suffered by the deceased who was a pillion rider, as the insurance policy was a statutory, hence here Tilak Singh.
Tilak Singh's case was an act only policy.
Yes, that's why the court said it won't be. It won't be liable. That's why, Lordship.
Yes.
That's I'm connecting the judgments together, Lordship.
No, but in Manwaras, you have not package policy that you can address in your written argument.
Okay, Lordship. I'll go through every word. Then, Lordship, Rajni Devi, Lordship, it is now a well-settled principle of law that paragraph 6, that in a case where third party is involved, the liability of the insurance company would be unlimited. However, compensation is claimed for death of the owner or another passenger of the vehicle, the contract of insurance being governed by the contract, the claim of the insurance company would depend upon the terms of thereof.
Okay, so your submission is even if the insurance company is liable, it will be liable
1
to the
lakh.
extent of 1 lakh only. Yes.
Then, Lordship, I come to this Balukishan Chavhan case, Lordship. This is a recent judgment of 23. Here, Lordship, paragraph 8. This pay and recovery part, Lordship, because I submitted a Janbay Manwara that the insurance company will pay and recover. That is from the apex court. Our High Court did not allow that. They went to apex court. Here, Lordship, paragraph 8. Hence, the only aspect for our consideration herein as to whether in the facts and circumstances of the present case, an order to direct the insurance company to pay and recover is required to be made. On this aspect, the law is well settled that if the liability of the insurance company is decided and they are held not to be liable, ordinarily, there shall be no direction to pay and recover. That is it. But ultimately, looking at the peculiar circumstances of the case, the court allowed that pay and recover in the case. But the law was made clear.
Ordinarily, it should not.
It should not. That is. Then, Lordship, I have on this line only, I have few other judgments, Lordship. Oriental versus Prithviraj. This relates to driving license, but why I'm showing these judgments, Lordship, whether insurance company can be made liable. These two judgments, basically on that continuation of what? Yeah.
No, your submission was that pay and recover can be directed only under 142 by the Supreme Court.
And these are also that they here they are insurance company is not made liable. Totally, apex court said no liability. Though these are relating to driving license, I just want to make the law clear that the pay and recovery, or when there is the contract is saying something, Lordship, whether the insurance company can be directed. The person has died, the claimants are entitled to compensation. Our liability will be as per the policy.
No.
Rest of the amount, the owner is liable.
I want to understand that your submission is that pay and recovery can be ordered only by Supreme Court in exercise of 142 of the Constitution of India. On what
Good judgments are there. And now I'll come to those, Lordship.
it has been stated.
In our High Court, I got two judgments here. That
Where it has been expressly stated that this power is not.
yes,
Okay.
yes, yeah, I'm coming. This is 2017.
Though that question will arise only if it is held that he is not, you are not liable.
Yes.
Because now there is no direction for pay and recovery.
No.
You are held liable. This is your alternative submission. That in the event you are found not to
Yes.
be liable, you should not be directed to pay and recover. On that line you are
On that
making.
line. Because first I showed Lordship Rajni Devi that if any liability, it will be as per the policy condition, 1 lakh of rupees.
Okay.
Now, Lordship, what I'm submitting that a person has died. They are under the MV Act, they are entitled to compensation. If our liability is 1 lakh, rest of the amount who will pay? It is the owner who has to pay. That's why I'm showing these judgments, Lordship. It is not that they won't get anything, but then if the quantum, Lordship, if we look at the quantum first, then this will be a case of remand that they have to prove it. Reliable evidence that the person was earning this much only. Their own documents cannot be contradictory, Lordship. Lordship, this judgment, our High Court, Lordship, at paragraph 22.
Which judgment?
Oh, this Lordship, Siba Prasad Ghosh versus Anima Nyok. 2017 5 GLR 267. Passed by our High Court, Lordship, Justice Surana passed.
What it says?
Lordship,
Para?
para 22, Lordship.
What it says?
In this connection, this court in the case of National Insurance versus Mahmood Mahmood, actually maybe I should have read about Mahmood Ahmed Laskar first. Anyway, has refused to direct the insurer to deposit the compensation as awarded by the learned tribunal and they recover the same from the owner. The relevant paragraph thereof is quoted below. I won't go to these. I'll come to that relevant part only. In case of person while referring the matter, pay and recovery are being passed in some cases by the Honorable Supreme Court by invoking powers under Article 142 of the Constitution of India. This court is of view that such power is reserved to the Honorable Supreme Court to order the insurer to make payment and then to recover, and such orders ought not to be passed by this court in exercise of appellate powers under Section 173 of the Motor Vehicle Act. Hence, the prayer made by the learned counsel for the respondent number 1 claimant to maintain the direction to the appellant to deposit the compensation as awarded by the learned trial court and then recover the same from the owner is refused, Lordship. And memo, next one I have is Mehboob Ahmed Laskar Lordship, here also. Here, as mentioned therein, that paragraph. Directly. Same thing is mentioned, Lordship,
Okay.
at paragraph 17.
Okay.
Then, Lordship, our High Court judgment, MSc Appeal 55 of 14, Lordship, another judge, Justice Manish Chaudhary passed this judgment. Here, in detail, this judgment is even more explicit, Lordship. And then
What is this? What is the citation?
it is, Lordship, Oriental Insurance Company Limited,
Versus?
Artichik, alias Sikh, CHIK, alias SIK.
Okay.
Para 36. In view of the aforesaid position of law, I am of
Okay,
the
I'll go through it because proposition is that pay and recovery cannot be ordered by any other court except Supreme Court. That is your submission.
that is my submission. And then I come to Nanjappan case, Lordship. If at all, pay and recovery is given by any court, apex court had in this judgment at paragraph 8 mentioned how it is to be done.
Apex Court has stated that it can be done.
Yes, how? Not
Then
only done.
it brushes aside other judgments,
No, this is of earlier time.
but it is an Apex Court judgment.
Yes, but those are also apex court judgment. I have shown.
No, you have shown our High Court's judgment saying that it can be done only under one.
No, no, no. Here, Lordship, the thing is that how it, if suppose apex court also in this case, the apex court directed that it should be pay and recovery, how it is to be done, that is what is there in paragraph 8, how it is to be done. Even if apex court says pay and
It is
recovery.
saying for itself.
No, how it is to be done. Before release of the amount to the insured, owner of the vehicle shall be issued a notice and he shall be required to furnish security of the entire amount which the insurer will pay to the claimant. The offending vehicle shall be attached as a part of, so how it is to be done, that is,
Okay.
this is Nanjappan case, Lordship.
Citation is?
Citation, Lordship, 2004, 13 SCC 224. Oriental Insurance Company versus Sri Nanjappan and others. So my humble submission, Lordship, that our appeal may be allowed and liability insurance company doesn't have any liability under the MB Act. Because the 1 lakh liability is under the policy that has to be taken from the insurance company directly.
Okay.
That liability, Lordship. Otherwise, under the MB Act, in this case, the passengers being gratuitous passenger, the insurance company does not have any. I'll give reply to whatever.
Yes, Mr. Datta. Will you start now or at 2?
I think I will try to finish off as early as possible, but 3 minutes will be too less.
Okay, then we'll start at 2. Or
Yes.
you can utilize these 3 minutes.
Yes, yes. I'll argue the last point first. Last point is with regard to the liability. Well, because the other, for other aspects, I'll have to take your lordship to the facts of the case, because full facts have not been disclosed to your lordship. So therefore, I'll argue the last point first. And so for the other points are concerned with regard to computation of income and all. So for that matter, I'll have to take your lordship to the facts and the evidence on record. So as far as the question is that whether the package policy being there, whether the liability of a gratuitous passenger would stand covered or not.
Under a package policy.
Under a package
That is
policy.
because
Now-
if that is answered in negative,
Yes.
then only
The
we have to
quantification
come
of
to the pay and recovery.
Yes,
If that is answered in affirmative, that
then
it-
that pay and recovery
that-
will
that
expect,
question will not
will
happen.
not come.
I
So-
have covered everything, Lordship.
so-
My
so-
submission is that.
No, he has come. So let me begin.
We'll
at-
start at 2.
Yes.
2.
Now, my lord,
Yes,
as I
yes.
have understood, principally, two contentions have been advanced. First, there is error committed in the assessment of monthly earning of the deceased, and consequently, it has resulted in an erroneous award. This is one argument. The second argument is that this offending vehicle being covered under a package policy and the claimant being a gratuitous passenger, she would not be entitled to any compensation more than rupees 1 lakh, which is the liability of the appellant insurer.
Yes.
These are the two questions. And in support of these arguments, my lord, these grounds, my lord, the judgment of the Honorable Apex Court have been cited. The principal question that arises in the appeal are therefore necessarily limited to the extent of coverage under the policy. Admittedly, there was a policy.
Yes.
So the question that is arising for consideration is the extent of coverage under the policy and the assessment of monthly earning of the deceased.
No, one submission is that gratuitous passengers are not covered at all.
That is what I said, my lord. Extent
At
of
all.
coverage under the policy.
Yes.
That is the principal question.
And if they are held to be covered by insurance policy, only to the extent of
1 lakh rupees.
1 lakh.
So that is essentially the question is the extent of the coverage under the policy.
Oh, yes.
Now, the extent, now there are two aspects on this particular point. First of all, whether there was a policy of insurance covering the risk of the vehicle or not.
That is not disputed.
Yes, that is not disputed. So essentially, the second question is what is the extent of coverage available under the policy? Now, so far as the extent of coverage under the policy is concerned, now the burden of proof on this point particularly rests upon the insurance company.
Okay.
I have lodged a claim before the tribunal. I have lodged a claim before the tribunal and I have said there's this vehicle in which the deceased was traveling. This vehicle stood covered under a particular policy. This much I have said in my claim petition. And to that extent, there is my evidence. Now, the dispute is with regard to the extent of coverage, and therefore, the burden of proof is on the insurance company to prove what was the extent. If your lordship will kindly consider their written statement, there is only a general statement that the liability of the insurance company is limited to the aspect of to the conditions of policy and coverage therein. Now, what is that condition that is not spelled out? There is only one statement in the written statement that your lordship will find at page 3 of their written statement, paragraph 15.
At which page is it?
Page 3 of their written statement. I don't have the, it will be perhaps page number 20 of the LCR. Sorry, 20, yes, perhaps page number 20 of the LCR it will be. It is paragraph 15.
Yes. Yes,
Now that liability of the answering OP,
yes.
if any, is restricted within the scope and terms of policy of insurance, if any, and the provision of the Motor Vehicles Act and terms of policy of insurance, if any, and the provision, this is repeated. I mean, maybe a typographical error, and rules framed thereunder with amendments from time to time. So this is only a general, or rather a bold statement, that their liability is restricted to the terms of policy. Now, what is the terms of policy? That is not spelled out. That is neither pleaded, and eventually there is also no question of any proof, because the insurance company did not lead any evidence.
No, but before burden shifts to them, onus shifts to them. Do you not-
Primary onus is on me to say that and to plead that the risk of the vehicle was covered under a policy.
And you are also covered.
And I am also covered. I am also covered. In my claim petition, I have stated that the risk of the vehicle is covered against a particular policy, under a particular policy. Now, if it is a question relating to the limit of coverage, what the appellants are trying to argue in the case is essentially a limit of coverage. Now, limited coverage was never raised as a question before the trial court, before the tribunal. If it was not raised before the tribunal, and if not.
But whether the tribunal was, if it was not looked into by the tribunal, whether the tribunal was right in awarding the compensation without looking at the policy.
No, tribunal has looked into the policy, and tribunal has understood the policy as to be one covering the entire sorts of risk.
Yes, whether the tribunal was correct in that.
Now to assess the correctness of the tribunal, the finding of the tribunal has to be viewed in contradistinction to the limits of coverage in the policy, which they are trying to urge now. Now, this particular assessment is not possible because of the fact that neither did they raise any pleading in the written statement.
No, assuming that there is no pleading, no specific pleading, but policy has to be gone through. What is there? What are the terms and conditions of the policy? Who is covered? Who is not covered?
Now terms and conditions of the policy, it is the defense of the insurance company that the extent of coverage is not there. So if it is their defense,
whether is it not apparent from reading of the policy that what is the coverage in respect of other?
My lord, my submission is that, my lord, as it is understood in common parlance also, a statutory policy is one covering the risk of a third party, and a third party is someone who is beyond the vehicle. Third party is someone who is beyond the vehicle. That is the common parlance and understanding of this statutory policy. And a comprehensive policy means it covers the risk of the vehicle as also the risks arising out of the use of the motor vehicle. My lord, in section 166 of the Motor Vehicles Act, my lord, only one kind of risk is visualized. That is risk arising out of use of motor vehicle. Because for all other risks, which is in terms of the risk of the vehicle, well, that are taken care of in other forum. The Motor Vehicle Tribunal, Motor Accident Claims Tribunal is constituted only for the purpose of considering the risks arising out of the use of motor vehicle. Now, use of motor vehicle essentially is, in terms of a comprehensive policy, will cover all sorts of risks. Now, if you are raising the point that all sorts of risks are not covered, then where is your pleading and where is your evidence? There is none. So therefore, my first submission on this aspect is this: there being no statement of fact and no evidence led by the insurance company as regards the extent of coverage under the policy, the finding of the tribunal cannot be disturbed.
Okay.
This is first submission. Second submission is that
No,
as,
okay,
Yes.
make your
yes,
submission.
yes, I'll-
One query is that we take it, there is no dispute that it was a comprehensive policy. So a question arises that if it is a comprehensive policy, then whether the liability can be limited
exactly.
by putting a value.
Exactly. As a matter of fact, my lord, that was the second submission I was going to make. Now, so far as this aspect is concerned, my lord, this question is concerned, my lord, the issue is no longer res integra. It has been settled by the Honorable Supreme Court. And on the earlier occasion, my lord, I had also placed a judgment of this Honorable Court, which has relied on a judgment passed by the Honorable Supreme Court on your lordship's brief. If it is not there, my lord, I'll again supply.
Judgments.
My lord, that is United India Insurance Company versus Urmila Chand. Yes. Now, my lord, yes, my lord, this is a case, my lord, where exactly the same question. Oh.
Yes.
My lord, this is a case where exactly the same question fell for consideration of this Honorable Court. And as a matter of coincidence, my lord, I was the counsel for the appellant. The specific ground that was urged in the appeal was that the policy in question being a comprehensive policy, the risk of the passengers being carried in the vehicle will not be covered and the limit of liability will be to the extent of rupees 1 lakh. That was the argument made by me. It was a case argued by me only. Your lordship will kindly come to the relevant paragraphs.
Then you were for the insurance company.
I was for the insurance company.
Which is the paragraph?
Your lordship will kindly come to paragraph 12 at page 334.
Yes. Yes.
The submission of Mr. Datta is threefold. Has your lordship got it?
Yes, yes.
The submission of Mr. Datta is threefold. That the deceased was a gratuitous passenger in the Indica car, and therefore he was not a third party in relation to the said vehicle, and thus the claimants are not entitled to any compensation from the appellant insurance company. That the insurance policy in question limited the liability of the appellant insurer in respect of unnamed passengers to a sum of rupees 2 lakhs. And as such, at any rate, the insurance company cannot be fastened with any liability to pay compensation beyond rupees 2 lakhs. And therefore, the judgment of the learned tribunal directing the insurance company to pay the earlier amount of so and so is not sustainable in law. Well, in that policy, the limit was 2 lakhs. In our present case, it is 1 lakh. That the learned tribunal took the monthly income of the deceased rupees 8,000 per month. Miller, that your lordship may skip because in the facts of the case, Miller, the income aspect is different. So first two questions your lordship has seen. The first two questions are exactly the questions which are
involved in this case.
Yes, which are the questions raised by the appellant insurance company. Now, kindly, your lordship can turn over the pages and your lordship can come to your lordship can come to paragraph 18.
18.
Yes.
Yes.
Now, paragraph 18 is the paragraph from which, Miller, the questions are taken into account. Well, that is with regard to the paragraph 18 is with regard to the assessment of income. Then your lordship will kindly come to paragraph 23.
Yes.
In Bhagya Lakshmi.
Yes.
And this Bhagya Lakshmi judgment has been relied on by the learned tribunal in assessing compensation in the present case. In
No, Balakrishna.
Balakrishnan. In Bhagyalalakshmi Supra, the apex court noted that the core question that arose for consideration before the High Court was as to whether the insurance policy covered the risk of passenger traveling in the car. The High Court had answered the said question in favor of the insurance company, meaning thereby that the policy did not cover the risk of the passenger traveling in the car. The policy in question in the said car was a package policy. Apex Court observed that the schedule of the policy did not indicate the limits of liability and the contract of insurance, if given the face value, covers the risk not only of the third party but also the persons traveling in the car, including the owner thereof. The Apex Court, however, taking note of a large number of decisions it had rendered earlier, wherein it was held that a passenger would not be a third party within the meaning of the Act in respect of Act policy, opined that the matter required deeper scrutiny and accordingly had referred the matter for consideration by a larger bench. The Tariff Advisory Committee had been functioning as Tariff Regulatory Authority till 31/12/2006, and from 1/1/2007, the IRDA, that is Insurance Regulatory Development Authority, has been functioning as the statutory regulatory authority, and it is not in dispute that they are entitled to fix the tariff as well as the terms and conditions of the policies issued by all insurance companies. Now, paragraph 25, your lordship can skip over and come to paragraph 26.
Yes.
The Apex Court dealt with the aforesaid circular, which circular has been quoted in paragraph 25. Aforesaid circular dated 16/11/2009. At paragraph 24 of Balakrishnan Supra, and relevant extract of paragraph 24 is reproduced below. The High Court had issued notice to the Tariff Advisory Committee and IRDA to explain the factual position as regards liability of the insurance companies in respect of an occupant in a private car under the comprehensive policy, that is package policy. Before the High Court, the competent authority IRDA had stated on 2/6/1980, it should be 2/6/1986, the pillion rider of a scooter motorcycle under the comprehensive policy, and the said position continues to be invoked till date. It had also admitted that comprehensive policy is presently called a package policy. It is admitted position, as the decision would show, that the earlier circulars dated so-and-so and so-and-so continue to be valid and effective, and all insurance companies are bound to pay the compensation in respect of liability towards an occupant in a car under the comprehensive package policy, irrespective of the terms and conditions contained in the policy. The competent authority of the IRDA was also examined before the High Court, who stated that the circulars dated so-and-so of the Tariff Advisory Committee were incorporated in the Indian Motor Tariff effective from 1/7/2002, and they continue to be operative and binding on insurance companies. In paragraph 26 of Balakrishnan, the Apex Court further held as follows. In view of the aforesaid factual position, there is no scintilla of doubt that comprehensive package policy would cover the liability of the insurer for payment of compensation for the occupant in a car. There is no cavil that an Act policy stands on a different footing from a comprehensive package policy, as the circulars have made the position very clear, and IRDA, which is presently the statutory authority, has commanded the insurance companies, stating that comprehensive package policy covers the liability. The insurance there cannot be any dispute in that regard. We may hasten to clarify that earlier pronouncements were rendered in respect of the Act policy, which admittedly cannot cover a third-party risk of an occupant in a car. But if the policy is a comprehensive package policy, the liability would be covered. These aspects were not noticed in Bhagyalalakshmi, and therefore the matter was referred to a larger bench. We are disposed to think that there is no necessity to refer the present matter to the larger bench, as IRDA, which is presently the statutory authority, has clarified the position by issuing circulars which have been reproduced in the judgment by Delhi High Court, and we have also reproduced the same. The judgment in Balakrishnan was rendered on 20/11/2012. The judgment in Surendranath Lumba was also rendered thereafter on the same very date, holding the same view, though reported earlier in 2012, 13 SCC so-and-so. The paragraph 29, the position that emerges is that an Act policy stands on a different footing from a comprehensive package policy. As the IRDA has stated, that a comprehensive policy covers the liability of the insurer for payment of compensation for the occupant in a car, there is no manner of doubt with regard to such liability of the insurance companies. However, the position would be different in case of an act policy. It is also manifest that all insurance companies are bound to pay compensation in respect of the liabilities towards an occupant in a car under comprehensive package policy, irrespective of the terms and conditions contained in the policy. In this case, the policy in question was a package policy is not in dispute. On a specific query on that of the court, Mr. Datta had submitted that it was a package policy and the insurance company is not assailing the finding of the tribunal that it was a package policy. Now, so far as the question of coverage is concerned under a package policy, it has been clarified by the IRDA, no authority less than IRDA, which is the regulatory authority of the insurance companies, before the Honorable Apex Court as well as Delhi High Court, that irrespective of the terms and conditions, the coverage is there. The coverage has to be taken. And as a matter of fact, my lord,
Now, what would be the extent of coverage? Can it be limited to the
no, because that
amount?
No, because that was the specific
From where we can,
my lord, in this case also the specific argument, specific ground was raised that since the policy in question mentioned 2 lakhs as the coverage, so the liability of the insurance company will be limited to 2 lakhs. That was the argument made. And the eventual determination of the Honorable Court is this, that irrespective of whatever may be there in the terms and conditions, you will have to undertake the liability. And most interestingly, Lord, the direction that the IRDA had issued, that in that direction, the IRDA had in fact directed all the insurance companies to withdraw from litigation all the cases where such grounds are being praised. I'm just now, if your lordship will allow me to read further to this paragraph 29.
yes.
Sorry, paragraph 31. Thus, there is no escape from the conclusion that under the comprehensive package policy, the insurance company will be bound to pay compensation in respect of the liability towards an occupant of a car, even if there is any term in the policy limiting the liability of the insurance company.
Oh.
As in the present case, and that such terms and conditions will have no bearing at all. Irrespective of the limitations imposed regarding liability in respect of individual passenger occupant in a private car, the insurance company will have to pay the entire compensation amount granted in respect of such occupant. Well, I don't think, my lord, I need to clarify it further. And this judgment has attained finality. There was no challenge to this by the insurance company in that case.
Okay.
And the particular statement that I was referring to, and your lordship, the Balakrishnan judgment, from the Balakrishnan judgment, which has been referred to by this honorable court in Urmila Chand, I'll draw your lordship's attention to a particular paragraph. Why the honorable Supreme Court had to say this with so much of force. Paragraph 16 of the
Yes.
Father, I'm just placing the Balakrishnan judgment. Your lordship can kindly go through the paragraph. I'll be drawing your lordship's attention to.
I have a copy.
So your lordship is having a copy. I think, my lord, your lordship's copy is one downloaded from legal.
Yes.
Yes. In that case, your lordship can kindly come to paragraph 17. which will be at page 7.
There are 17.
Yes,
Yes,
at page 7.
yes,
At this stage,
yes,
it is apposite to note that when the decision in Bhagyalakshmi was rendered a decision of the High Court of Delhi dealing with the view of the Tariff Advisory Committee in respect of comprehensive package policy had not come into the field. We think it apt to refer to the same as it deals with certain factual position which can be of assistance. The High Court of Delhi in Yashwant Luthra and another versus United India Insurance Company and another reported in so and so after recording the evidence of the competent authority. Your Lordship will kindly mark these words. After recording the evidence of the competent authority of Tariff Advisory Committee and the Insurance Regulatory Development Authority, reproduced the circular dated 16/11/2009, issued by the IRDA to CEOs of all insurance companies, restating the factual position relating to the liability of insurance companies in respect of pillion rider on a two-wheeler and occupants in a private car under the comprehensive package policy. The relevant portion of the circular which has been reproduced by the High Court is as follows. Now, the circular portion your Lordship can skip over and your Lordship can kindly come to the next page.
page 9. Page 9, para Roman 1.
It is page 8, Lordship. Down below.
Yes. Based on the anonymous.
Last paragraph. The authority wide circular number so and so issued under so and so file number has reiterated that. Last paragraph in page 8.
Yes.
The authority wide. Sorry. The
Based on.
penultimate paragraph. The above circulars. After the circulars have been quoted, the above circulars make it clear. On page 8.
Page 8. Yes, page 8. Yes, the above circulars.
The above circular, the previous page, the circulars are quoted.
Yes.
Now, the above circulars make it clear that the insured liability in respect of occupants carried in a private car and pillion rider carried on two-wheeler is covered under the standard motor package policy. A copy each of the above circulars is enclosed for ready reference. The authority-wide circular number so and so dated so and so issued under file some so and so has reiterated that pending further orders, the insurers shall not vary the coverage, term and conditions, wording, warranties, clauses and endorsements in respect of the covers that were under the erstwhile tariffs. Further, the authority-wide circular number so and so permitted to abridge the scope of standard covers available under the erstwhile tariffs beyond the options permitted in the erstwhile tariffs. All general insurance are advised to adhere to the aforementioned circular and any non-compliance of the same would be viewed seriously by the authority. This is issued with the approval of the competent authority. Now, thereafter, now next page, later, the paragraph 18.
Yes.
Paragraph 18, the High Court has also reproduced a circular. Has your Lordship got it?
Para 19.
The paragraph 18 will be at page 9.
Yes.
Hold on.
Page 9.
Yes. paragraph 18, the High Court has also reproduced a circular by IRD dated 3/12/2019. It is instructive to quote the same. Now, regarding liability of insurance companies in respect of occupant of a private car and pillion rider in a two-wheeler under standard motor package policy, also called comprehensive policy, pursuant to the order of the Delhi High Court dated so-and-so, in appeal number so-and-so, in the case of so-and-so, the authority convened a meeting on November 26, 2009 of the CEOs of all the general insurance companies doing motor insurance business in the presence of the counsel appearing on behalf of the authority and the learned amicus curiae.
Yes.
Based on the unanimous decision taken in the meeting by the representatives of the general insurance companies to comply with the IRDA circular dated so-and-so, restating the position relating to the liability of all general insurance companies doing motor insurance business in respect of occupants in a private car and pillion rider on two-wheeler under the comprehensive package policies, which was communicated to the court on the same day, that is November 26, 2009. The court was pleased to pass the order received from the court master dated so-and-so, Delhi so-and-so, is enclosed for reference and adherence. In terms of the said order, the admitted liability of all the general insurance companies doing motor insurance business in respect of the occupants in a private car and pillion rider on a two-wheeler under the comprehensive package policies, you are advised to confirm to the authorities strict compliance of the circular dated so-and-so and orders dated so-and-so of the Delhi High Court. Such compliance on your part would also involve, this your lordship may kindly mark, withdrawing the plea against such a contest wherever taken in the cases pending before the MACT and issue appropriate instructions to their respective lawyers and the operating officers within 7 days. That strict instruction was to withdraw contest on this ground. And Balakrishnan was a case, my lord, where the appellant was none other the appellant before your lordship now. Knowing fully well that there is a judgment of the Honorable Supreme Court on this point, covering this aspect, they are still before this Honorable Court on appeal. In my respectful submission, my lord, this is absolutely abuse of process of court. This is in gross abuse of the process of the court. With respect to all appeals pending before the high courts on this point, my lord, the direction was not limited to withdraw contesting from the MACT alone. It was also from the High Court. With respect to all appeals pending before the High Courts on this point, issuing instructions within 7 days to the respecting operating officers and counsel to withdraw the contest on this ground, which would require identification of the number of appeals pending before the High Court, wherever filed by the claimants or the insurers on this issue within a period of 2 weeks. And the contest on this ground being withdrawn within a period of 4 weeks thereafter. As far back as in the year 2009, my lord, this direction was given. And this was quoted with approval in a case rendered between National Insurance Company and Balakrishnan. National Insurance Company is in appeal before your lordship. My humble and respectful submission before your lordship is this, my lord. There cannot be any other example of a misuse of the process of court other than the appeal filed in the present case. And this is the judgment which the Honorable Tribunal, Learned Tribunal has referred to.
Okay.
So therefore, my lord, my submission so far as the first ground is concerned is that, my lord, first of all, there being no evidence, no plea, the tribunal's finding cannot be assailed on any count. And even if it is assumed that there being a circular, there being a comprehensive policy, whether the terms and conditions are to be looked into or not, etc., my lord, the questions have been settled at rest.
Terms and condition.
So the Honorable High Court in Urmila Chand's case has clarified that it is of no use.
Even if it restricts the.
Even if it is redundant, because ultimately it is the decision of the Tariff Advisory Committee, my lord, which is nowadays the IRDA, which is the regulatory body. The regulatory body's instruction is very clear, which the Honorable Supreme Court had recorded in Balakrishnan case, that you are not to agitate this as a ground. Because the previous circulars, which are still holding the field, mandate that this cover has to be there. That's why, my lord, I read out this judgment also. So therefore, it cannot be argued that since there is a limit of liability in the policy, the liability of the appellant cannot extend beyond what has been.
This was not addressed by Balakrishnan, but by this, our High Court.
No, it was also addressed in the Balakrishnan Miller. I am not reading the subsequent paragraphs. In subsequent paragraphs, it is clear which has been quoted in the High Court judgment. Paragraph 26 has been quoted in the High Court judgment, Lordship.
There are no 26.
In 26 of this judgment, it's Urmila Chand's case.
Urmila Chand
In
has,
Urmila Chand's case, in paragraph 26, the relevant observation of the Balakrishna has been quoted.
yes, no, Urmila Chand is saying that irrespective of terms
Yes.
and condition.
Yes. And
liability-
in Urmila Chand's case, paragraph 26, the observation of the Honorable Supreme Court in Balakrishnan case in the context of the circulars that have been quoted. Just for an eye comparison, your Lordship can see paragraph 26 of the Urmila Chand's case. Para 24 of the Balakrishnan case has been reproduced there. Now,
Oh, yes.
it is there,
is
and
in para-
in Balakrishnan case also, your Lordship can kindly come to paragraph 21.
That is para 24, it has stated.
Yes, in para 21, your Lordship may kindly come. Hello, the paragraphs numbers will be different because of the, my lord, these are downloaded from different softwares. So there can be difference in the paragraph numbers, but the substance your Lordship will find.
Now, this phrase, irrespective of terms and condition,
Yes,
used by Balakrishnan,
yes, your Lordship will
includes
everything.
limiting the liability also.
Also.
Even if it is limited by terms of the comprehensive policy, that has to be ignored.
That has to be ignored. And in paragraph 21 of the Balakrishnan judgment, your Lordship will kindly come to.
Yes.
In view of the aforesaid factual position,
Yes.
there is no scintilla of doubt that a comprehensive package policy would cover the liability of the insurer for payment of compensation for the occupant in a car. There is no cavil that an act
Would
policy.
cover the liability of the insurer.
Yes, for payment of
payment.
compensation for the occupant of a car. Now, this paragraph has been quoted. This here it is 21, but in the Urmila Chand case, my lord, the SCC it is from the SCC, so it is 26 there. In Urmila Chand's case, your Lordship will kindly come to paragraph 27. There, this paragraph has been quoted as paragraph 26. Because the reference was from SCC, so in SCC, the paragraph number is different.
So there cannot be any question as regards the extent of liability.
Exactly. And even even if the first submission, my first submission is ignored, that there is no pleading, there is no evidence, and therefore it cannot be. Even if that is ignored, my lord, on the face of this determination, one is by this honorable court and the other one is from the honorable apex court. There cannot be any doubt
Regarding the extent of,
regarding the extent of coverage.
okay.
So this is my submission. One anticipating one counter submission that your Lordship sitting in a single bench, your Lordship can always take a different view. That can be that can be a submission, counter submission, Lord. Whether in the Procedural case, which the appellant has also relied on, it is a 3-judge bench decision of the Honorable Supreme Court. Right? No, 3. In Procedural case, my lord,
5-judge.
it is a no. It is the judgment delivered by the your Lordship will kindly see the judgment delivered by Honorable Justice Deepak Mishra. It has been sounded there that since there is a previous decision of a coordinate bench, the subsequent coordinate bench cannot afford to ignore it.
No, ignore it. It has to refer.
Yes.
It has to refer
Yes.
to high.
Yes. That is what has been stated there. So therefore, my respectful submission is this, my lord. Since the position has been very explicitly laid down in 2-3 pronouncements of the Honorable Apex Court as well as this Honorable Court,
Okay.
this is not open. This is no longer open for any debate.
Yes. And it is not only our High Court,
There are
Our,
other
hi-
high courts.
no, our High Court has, the earlier judgment has relied on the observation made by Balakrishnan in para 24.
Yes. And that is, actually the things had originated from Honorable Delhi High Court. In Delhi High Court, that Yashpal Luthra's case, my lord, this point was gone into. Then the circulars had been produced. The persons of the authorities were examined by the court, and the resultant decision has been rendered, and which has been subsequently approved in Balakrishnan.
Okay.
So on the face of these two pronouncements, my lord, my humble and respectful submission is that this ground does not subsist for any challenge. Now coming to the other ground, which is the assessment of income.
Yes.
Of course, my lord, in the memo of appeal, though it has not been argued now today, but in the memo of appeal, they also took a ground of multiplier, choice of multiplier. So since it has not been argued, my lord, I assume that point, that argument.
Not trace.
So I checked it, so I found that it is correct 50 years. I
So
calculated.
So it is not trace.
So the other ground is with regard to the assessment of compensation in the view of the salary of the deceased. Now that, for that matter, my lord, two documents have been shown to your lordship. First is Exhibit 16 and the another is Exhibit 32. And along with Exhibit 32, certain other documents have been also shown to your lordship, which have been stated to be the income tax assessment return.
Exhibit 17 and Exhibit 19.
Well, that I am coming later on. Basically, the first submission is on Exhibit 16 and 32. A contradiction shown as in between these two exhibits. Now, if your lordship will kindly come to the Exhibit 16.
Yes.
Now, one thing before I read out this to your lordship, one thing I remind myself, the deceased was a government employee, a permanent government employee, and the salary of the deceased was proved by production of service book.
Service book.
Service
book has not been.
Yes, it is one of the exhibits. My lord, I'll bring it to you. That's why I said, my lord, the full facts have not been presented to your lordship. Now, your lordship knows that a person's salary, particularly a government servant's salary, for proof of salary, there cannot be any better proof other than the service book. Because whatever a person earns or generates as income is reflected in the service book, and that is maintained by the employer, that is the government of Assam. And in this case, the service book was produced by an independent witness who was summoned by the court, not by me. Your lordship will kindly come to Exhibit 16 first.
Yes.
In Exhibit 16, your lordship will find the basic pay has been indicated, although the word basic is not there, but anyone who is conversant with the service laws, they will know that it is the basic pay. Now, basic pay is indicated as 17,510, and thereafter the other emoluments, which are DA, HR, MA, etc. By adding those, this comes to 41,749. And this certificate was issued by the principal of the school in which the deceased was working.
Yes.
And this certificate is dated 26th of August 2016. Your lordship has noticed this. Now, if your lordship will kindly come to Exhibit 17, then in Exhibit 17 there is an apparent increase in the basic pay. In the page 6, Exhibit 16, the basic pay is, with the other emoluments, it is 41,749, which in Exhibit 7 comes to 52,364.
Yes.
Now, here the principal increase is with regard to the basic pay, which has become 47,700.
Yes.
And consequently, my lord, because of the addition of the other components which are statutorily available to a government employee, my lord, the amount comes to 52,000. Now, your lordship will kindly come to the next page, next exhibit, that is exhibit 30.
30.
Exhibit 30, 30. Exhibit 30 is a notice, my lord, which was sent from the tribunal to the inspector of schools.
Just a minute.
Second paragraph of the notice, your lordship may kindly read.
Right.
I'll read it out to your lordship, my lord, second paragraph. That,
Yes, please read slowly.
yes, exhibit 30. Oh, background.
Please not get.
Has your lordship?
Notice by whom?
By, it was noticed by the Seristidar from the Motor Accident Claims Tribunal, Kachar.
It is not there in the.
Exhibit, I may find it out, lordship.
Okay, you read, I will.
That as Sabita Das was an assistant teacher in Siddheshwar Higher Secondary School, Katigora, under the Education Department, so the details in connection with her service is very much essential for the just and proper decision of her case. You are therefore hereby asked to depute the accounts officer of your department for providing her length of service, that is date of joining and date of retirement had she would not have died, details of monthly salary, gross and net, including the deductions being made under different heads, details of income tax that has been paid by her for the financial years so and so and so and so, and the details pertaining to her legal heirs as per your official records. The said accounts officer shall have to appear in person with all the relevant documents duly signed and sealed by the competent authority on the day of so and so for giving evidence in this case.
Okay.
This was the exhibit 30 is the notice, my lord, that was sent from the tribunal to the department, the education department, inspector of schools. Now, in pursuance of this notice, my lord, the exhibit 31 came along with other documents.
31 is the service book.
31 is the service book. And I need not elaborate on what a service book would include in respect of a government employee. Only thing is that, my lord, the difference which your lordships have noticed in the exhibit 16 and 17, they have an explanation in the service book. If your lordship will kindly come to the last page of this service book.
Yes.
There your lordship will find the basic salaries are indicated against column number 4, pay in substantive post.
Yes.
Now, the last salary before the revision of pay scale your lordship got it.
Yes.
The last salary indicated is 17,500 or 510 maybe. Yes, 17,510.
Before revision.
That is before revision. And this 17,510 is reflected in exhibit 16.
Okay.
Now, if your lordship will read down below, revised pay scale, that is 14,000 to 49,000 pursuant to revision of pay 2017. In 2017, my lord, there was revision of pay scale by the government of Assam, and thereafter the pay scale was fixed as 46,310.
Yes.
And this 46,310 was given a retrospective effect. Usually in all revision of pay, my lord, it comes with a retrospective effect. Because ROP 2017 came with effect from 1/4/2016. Your lordship knows that.
Yes.
So for 1/4/2016, the pay was 46,310. That is because of the retrospective effect of the rules, pay rules. And based on that, my lord, the pay was revised to 47,700 on 1/7/2016. What is the error? This 47,700, which is reflected in Exhibit 17 as the basic pay, this is only natural because the pay scales always come with retrospective effect. These are, I have at least in my career so far doing service matters, my lord, I have never found a pay scale, pay revision coming with a posterior effect. It always comes with a retrospective effect, and even
From a particular date.
from a particular date. And your lordship has also, I may take liberty to say that your lordship has also drawn the revised pay with effect from 1/4/2016 because of the pay rules in 2017.
From a particular date.
From a particular date.
No, the one of the limb of submission by.
Now, I'm also addressing that, my lord.
Okay.
Now, if you're, so, my lord, apparently, my lord, I do not know the reason. If it was missed out by the appellant's counsel, my lord, it can be one thing. But if it was not missed out, then it should be understood as a deliberate attempt not to place it. Now, the apparent dichotomy in the basic pay, as indicated in Exhibit 16 and 17, are explained in the service book. And there cannot be any better evidence. Your lordship has said best evidence. The tribunal has taken the best evidence into record. Now, other components, as far as the other components are concerned, like DA, HRA, and etc., these are always at a pro rata basis. DA is 2%, HRA is on a certain ceiling. So these components are added and the resultant figure is arrived at. Now, there can be, if there is an arithmetical miscalculation, that arithmetical miscalculation per se cannot be a ground to say that the tribunal has committed an error in picking up a particular figure. Now, taking a cue from this, my lord, I can also explain the other differences in the other exhibits. Now, in Exhibit 32, Exhibit 32 is, my lord, last part pay certificate, and it has been shown to your lordship to content that the figure 52,000, or in the total figure, there is a overrating.
There is a overrating in the figure.
Yes. Now,
two has been made one.
Has to be, my lord. 47,700 DA is available 2% for that class of employee. 47,000, 2% of 47,700 cannot be 1,900. Initially, that was 1,900, and therefore it had to be corrected.
Okay.
Well, the tribunal holds an inquiry. It does not hold a trial, and the trappings of Evidence Act are not applicable. Long time back, 1960, it was said by Supreme Court. The trappings of civil court is also not available to the tribunal.
Yes.
It is a summary inquiry, my lord, where on of course, on preponderance of probability, on application of some amount of guesswork, my lord, the compensation is arrived at. There is no, it cannot, for that matter, it cannot be said that there is a gross dereliction of the judicial process. The tribunal has picked up the best evidence available, which is the service book. There cannot be any better evidence because the income tax returns which are also submitted, these are also having a basis on the service book. Beyond service book, it cannot be granted. So far as the official income is concerned, if she was having other source of income other than the salary, then of course it can be reflected in the income tax return. Now, this DA, 2% DA to 47,700, 2% is 954. Erroneously, it was written as 1954. Okay. So therefore, my lord, this correction in the final figure. Now, I am also explaining to your lordship the subsequent pages. Exhibit 20. Exhibit 20 has also been shown to your lordship.
Yes, where?
Now, in Exhibit 20, one objection has been taken that gross salary income has not been indicated on the top.
Yes.
Just below the PAN number. How does it tilt the balance How does it tilt the balance? It is for financial year 2014-15. Victim died 2016. Huh? Huh? Victim died 2016. This is of financial year 2014-15. The assessment year is 15-16. That is year ending 2016, March 31st. Even if it was not recorded, or even if some miscalculations have been given here, assuming for a minute, how does it tilt the balance in the face of the evidence which is coming up in the form of service book, entries in the service book? And the next page,
Yes. Yes.
next page is the computation of total income for the financial year 2013-14. How is it relevant? What was the salary of the deceased in the year 2016? Even if something, and there has to be difference, my lord, because the payrolls came with a retrospective effect. So naturally there will be changes in the income. Naturally there will be changes in the income. And the departmental witness who came with the service book pursuant to a notice of the court, he not only proved the service book, these are proved in original, my lord.
Yes.
He not only proved the service book, he also produced the computation in the book itself, which is statement of gross salary and deductions for all the years. In the subsequent pages of exhibit 32, exhibit 20, your lordship will find this. How the salary was increased from time to time and how it came to 47,700. So therefore, my lord, it cannot be said that there was any error, either factual or legal, committed by the learned tribunal in assessing the income. These, in the facts of the case, my lord, these
Her
exhibits.
submission was that the claimant failed to establish the income of the deceased.
My lord, my respectful submission is that this argument will not hold water. The reason being that there are as many as 5 documents relatable to 5 different points of time.
Therefore, there is difference.
Therefore, there has to be difference. Therefore, there has to be difference. It cannot be a static figure all the time.
Okay.
And the reason, my lord, I have explained in the face of the exhibit service book. The objection, what was the objection taken during cross-examination? The carbon, what we call the Xerox copies were produced. It has to be Xerox copies because service book is a property of the state government. Service book is state government's property. It will be proved in original. That is what is being done in trial court every time.
It was verified with original.
It was verified with original.
Okay.
So therefore, one can take an objection, my lord. Whether the objection is sustainable or not, that has to be seen. For the sake of argument or for the sake of making out a case, one can take an objection, one can try to make out a ground. But whether or not that ground is sustainable, that has to be seen. And once a statement of this particular witness, as revealed in the cross-examination, that has been brought to your lordship's notice, PW3, the cross-examination of PW3.
Where he says that
I have no full knowledge regarding, how can he have? He is an official of the department. He does not have any personal direct involvement with the matter. Somebody has authorized him. He has come on government authorization. The question must have been that what are the discrepancies in the exhibits? Looking at the type of argument that has been made, my lord, I can only visualize that possibly that was the question put to him, that there are discrepancies in the exhibit 16, 17, 18, 19 and all. So he said, I have no full knowledge regarding the exhibits. Has to be. He is not the author of the service book.
Okay.
So therefore, in picking up the occupational income of the victim, which is based on the best evidence produced, well, in my respectful submission, the tribunal did not commit any mistake. neither factual nor legal. Because for a government employee, my lord, service book is the sort of what we call as the sheet anchor of his official records of his service career. Now, in the cross, there was also no suggestion that this witness had come to depose falsely or in a mala fide with a mala fide intention. Why a general government employee will come to depose falsely? He has got no personal interest in the business in the case. Therefore, this evidence, ultimately, it is the appreciation of the evidence of a particular witness. So, this evidence does not fail for the reason of certain apparent contradictions in the figures. The figures are explained by the pay revision. Now, another argument was made with regard to interest on future prospect.
Yes.
Now, in interest on future prospect, my lord,
Case was also cited.
yes, but that case has been taken into account, and there are two judgments till now. I could find only two, my lord. There are two judgments on this honorable court that I will give to your lordship with the written submission. One judgment is by Honorable Justice Manish Chaudhary, and the second judgment is by there is also a judgment by Supreme Court on this point. Now, in the judgment decided by Justice Chaudhary, my lord, there is a reference to the particular judgment which the appellants have submitted before your lordship. Sulochana, MSc Appeal 96. Now, MSc Appeal 96, my lord, I saw the order. MSc Appeal 96 does not lay down any law, because there is no discussion, there is no reasoning given why it should. It is simply accepting the submission of the Learned Counsel that the eventual determination was made that future prospect, the interest cannot be granted. Now, reading out from the judgment of Honorable Justice Manish Chaudhary, my lord, I'll just read out one paragraph, my lord. It echoes my submission. In so far as the contention of the Learned Counsel for the respondent insurer as regards interest on the component of future prospect is concerned, it is seen that in the decision in MSc Appeal number 96 of 2009, no reason has been assigned for not granting interest on the component of future prospects. On the other hand, it is noticed that in the decisions in so-and-so versus so-and-so and so-and-so versus so-and-so, the Supreme Court, while assessing compensation, has granted interest on the components of future prospects also. Well, I'll be placing that judgment before your lordship. And apart from these two judgments of the Honorable Supreme Court, which Honorable Justice Chaudhary has referred in his decision, my lord, there is also a recent decision. My lord, this is rendered by a bench of Justice Deepak Mishra, Khanwilkar and D.Y. Chandrachud. Judgment was authored by Justice Chandrachud. This is reported in 2018. So I'll be placing these three in my written submission. I'll submit. Why, my lord, the logic, I can understand it this way. Why there will be an interest on future prospect? In a claim arising out of an accident, my lord, of course, it has been said so in the context of claims under workman's compensation, but the basic principle will also apply in these cases. In the cases of workman's compensation, my lord, there is a particular provision in the Workmen's Compensation Act which says that if the compensation is not paid when it becomes due, then you'll have to pay penal interest, and the interest component is much higher there, is 12%.
Yes.
Now, there were much debate on whether when the compensation becomes due, because in a proceeding under workmen's compensation, particularly in cases of injury, the final amount of compensation is determinable only when the compensation comes to be assessed by the Workmen's Compensation Commissioner. These kind of arguments were being made. Now, the eventual determination that the Honorable Supreme Court gave that particularly in cases of death and particularly in cases where permanent partial disablement occurs, there is a schedule given in the Act itself relatable to the loss of earning capacity. So the compensation becomes determinable immediately on the date of happening of the accident. So the idea is to compensate the victim or the survivors of the victim with the loss immediately on the date of arising of the tort, because it's a tortuous liability. So that is basically the idea with which, my lord, the compensation becomes, it has been held so that it becomes payable on the immediately on the date of accident. Now, in a proceeding under the MSCT claim, where, my lord, the determination takes time because of the procedures being followed by the court, and compensation happens to be decided at a future point of time. Normally, this is compensated. The delay in payment of compensation is compensated by awarding interest on the principal award of compensation. So far as the future prospect is concerned, my lord, the loss of future prospect also occurs immediately on the date of happening of the accident. If there is any, if there is permanent disablement or if there is a death, then the loss of future prospect also occurs on the date of accident. So basically, this is the idea, my lord, that since it becomes a liability on you, and you have not discharged the liability immediately on the date, so therefore you pay interest. So with this objective being in mind, my lord, it has been held in the judicial pronouncements that I have referred to your lordship, and I will be submitting the copies also, that there can be, and the tribunal has explicitly referred to it. So on all these three counts, my lord, in my respectful submission, the grounds urged in the appeal, particularly the one for the particular ground as regards the coverage is concerned, my lord, I will humbly submit that your lordship should impose cost. Not only dismissing the appeal, but also imposing cost. Because this way of proceeding with an appeal should not be allowed, should not be permitted, unless this was said long time back in the year 2009, 10, etc. And unless some warning is sounded by the Honorable Court, my lord, this will not stop. There has to be a limit to everything. You are the party to the proceeding even before the Supreme Court. You know of the judgment, and still you urge this ground. The direction of this IRDA was very specific, that withdraw all contest wherever you are urging this as a ground. And you are coming up with an appeal in the year 2023 with this kind of a ground. Therefore, my lord, there should be an exemplary cost, at least to sound a word of caution.
Okay, unless they take ground, how law would be?
No, my lord, I have not said so. I have not said so as far as the ground on assessment of income is concerned.
Okay.
They can assessment of income.
I have noted your submissions.
Yes. So therefore, these are the three grounds. And lastly, but most important, my lord, since the question of interest is involved, accident had occurred in the year 2016, and they came on appeal after the judgment was delivered in the year 2019. They made a statutory deposit for the purpose of getting a stay. For the purpose of getting a stay of the judgment, they made a statutory deposit, the conditional deposit with the registry. We filed applications for withdrawal that they have registered so far. Resultantly, because of the resistance of the appellant company, we have not been allowed to withdraw even a single rupee from the amount of compensation. 2016 to 2024, 8 years have gone by.
Suppose this appeal is dismissed, assuming that appeal is dismissed, you will get interest for that period.
I will certainly get interest, because interest is also my right under the statute. It flows from the section 173 itself. Question is, my lord, whether on such a vexatious ground, it can be permitted to be obstructed. Something was, what is the objective of granting compensation? To immediately tide over the crisis that befalls upon the victim's family. And knowing full well the fallacy of the particular ground, I am not saying about the assessment of compensation, because there I have said with a caveat that either it might have missed out the attention of the appellant's counsel, or, my lord, she has not chosen it appropriate to point out. So whatever be the reason, assessment compensation I am not saying. But so far as the first ground is concerned, because all along, my lord, this has been heard that since there is no limit, there is limit of coverage and there is no scope for granting further compensation more than rupees 1 lakh, so we should not be permitted to withdraw. And in an analogous matter, my lord, There was another victim in the vehicle. In the analogous case, my lord, without any cavil, they have allowed compensation of 1,59,000 without raising any plea that there is limit of liability and this should not be granted.
That is the amount, 1 lakh
So this
with interest.
this they have paid 1,49,397.
So that is covered, 1 lakh something. And
So
with interest.
therefore,
What is the wrong in that?
therefore, the award was for 1,25,155, not 1 lakh. So therefore, the particular contention which has been made in this case, this is utterly fallacious and it is motivated ground. They know it fully well that this ground will not survive. But still they have shown this ground to resist the withdrawal of part compensation. So therefore, my lord, these are the two submissions, my lord, based on which, my lord, I will submit. Apart from allowing dismissing the appeal, my lord, your lordship should grant some cost. Let it be a token cost payable to the legal services authority. But at the same time, my lord, this should come as a warning from your lordships.
Okay,
That's all.
be brief.
How is the insurance company lordship is physically or mentally involved against this particular claimant lordship? What is the interest of the insurance company? The way it is submitted as if the insurance company has a particular case against this particular and no other victims. And that's why we have paid 1 lakh. For 25,000, should the insurance company be coming to the Honorable Court lordship? The compensation therein was paid because that was the liability. Now, lordship, Balakrishnan case, I'll go the way they have given. Balakrishnan case, lordship, and also our High Court. And that's why a caveat is given that if lordship finds that lordship cannot go by the judgment passed in Urmila Chand's case, lordship, this can be referred to larger bench. That is why I'm mentioning this, lordship, because lordship, they are reading till 21. In Urmila Chand also, till 21 is mentioned of Balakrishnan. Let me read 22, lordship, and 23
Of
Balakrishnan judgment, lordship. That's why the policy was important, lordship. Th 23. In view, 22. In view of the aforesaid legal position, the question that emerges for consideration is whether in the case at hand, the policy is an act policy or comprehensive package policy. There has been no discussion either by the tribunal or the High Court in this regard. True it is, there before us, Annexa P1 has been filed, which is a policy issued by the insurer. It only mentions the policy to be a comprehensive policy, but we are inclined to think that there has to be a scanning of the terms of the entire policy to arrive at the conclusion whether it is really a package policy to cover the liability of an occupant in a car. In view of the aforesaid analysis, we think it appropriate to set aside the finding of the High Court and the tribunal as regards the liability of the insurer and remit the matter to the tribunal to scrutinize the policy in a proper perspective and if necessary by taking additional evidence, and if the conclusion is arrived at that the policy in question is a comprehensive package policy, the liability will be fastened on the insurer. That's why we had filed that IA lordship, the terms of policy. I'm bringing a difference. Why this particular case? Like it is made out that the insurance company is...
No, but you are admitting that it is a comprehensive policy. On that, you are not.
I have annexed the policy, lordship, package policy. But the thing is, what this apex court says is that the terms have to be looked into in Balakrishnan, because the tribunal relied on Balakrishnan. They are also now relying on Balakrishnan, lordship. What is the difference between Urmila Chand and this particular case, lordship? The difference is that in their claim petition, in their evidence, in the judgment, in all the places, it is mentioned that they were gratuitous passenger, lordship. Occupant of the car or the IRDA regulations, lordship, we are not against those. We do not file cases. As they are saying, exemplary cost is to be imposed. Why not exemplary cost be imposed on the claimant's, lordship? Lordship, they are relying on the income document. That time Lordship told me, so I went through, during recess, I went through the documents, Lordship. Exhibit 17 and exhibit 32, Lordship said that one is the.
Before you make this in Urmila Chand section, paragraph 24 has been referred to.
Yes. And thereafter
Which
also
is the para in this judgment?
This
In-
21.
It
in
is
the
No, no, no.
copy that I have submitted to your
Submitted,
lordship,
yes.
that will be paragraph 20.
corresponding paragraph in the of this legal.
Yes, I'm just giving it.
You have 24, Miss Majumdar.
No, Lordship, no, not.
Balakrishna,
No, no, no. 24 is my last judgment, last paragraph in my judgment.
24,
24.
24, para 24 of Balakrishna's judgment.
Yes,
No.
I have in my copy, Lordship, 24 is the last paragraph of the judgment. Consequently, because this paragraph,
If you read that paragraph in
no, that is only
somewhere-
3 lines, Lordship. Consequently, the appeal is
No,
allowed
no,
to the extent.
no, not
Uh,
that.
Well, in the Urmila Chand case, Miller, the paragraphs have been quoted from SCC. That's why there is a difference.
No, so that she can read, I just want to point out.
Well, I'm still giving it
But I have
Your
my
lordship.
judgment also.
Urmilachan you go to para 26.
The High Court has issued notice.
No, that is
The
not.
apex court deal with the above said circular.
The High Court has issued notice.
Huh.
This is quoted from Balakrishnan,
Huh.
para 24.
Yes,
Somewhere in between,
yes.
there is a observation.
Some dots are there, then the.
Now you read, it has also been admitted. Para
It
one,
has
two-
also been admitted that the comprehensive policy is
Is
presently called a package policy.
Yes,
It
read
is
that line.
admitted position as the decision would show the earlier circulars dated so and so continue to be valid and effective, and all insurance companies are bound to pay the compensation in respect of liability towards an occupant in a. Lordship, that's why I want to bring the difference between other cases and this case. Lordship, here occupant, we do not have, Lordship, we are paying, the insurance company is paying. Occupant, we do not have any problem, Lordship. Had they been occupant, there is no question. But they said they are gratuitous passengers. They
No,
are
no.
themselves mentioning
She was also an occupant.
gratuitous passenger.
She was a gratuitous passenger,
They themselves mention.
but a gratuitous passenger is also an occupant of a car.
No, Lordship, that has to be, that gratuitous passenger.
It does not exclude gratuitous passenger, this observation.
No, Lordship,
It only
occupant.
a gratuitous passenger may be, an occupant may be a gratuitous passenger, he may not be a.
That's why I showed
It
Tilak
is-
Singh, Lordship. Tilak Singh judgment, why I showed.
No.
And Manwara also I showed because of that only, Lordship. They were occupants in that Tata Sumo, Manwara case.
Occupant is a genus.
Yes.
And gratuitous passenger is a species of that genus. All occupants may not be gratuitous passenger,
Yes.
but some of the occupant may be gratuitous passenger.
And
And
here-
this judgment observation of Balakrishnan does not differentiate
Yes.
between gratuitous passenger and occupants.
Now,
Like, that's why-
this is quote from paragraph 18.
Let us submit.
No, your lordship
Oh,
was
para 18.
para 18. In the compilation that.
No, I was asking because I wanted to point out.
Yes, it is from
Oh,
para 18.
I want your submission on
My
this.
submission, Lordship, is occupants, insurance companies, they do not deny. But here, Lordship, what happened in
If the
this,
occupant is a gratuitous passenger,
it won't be covered because of Tilak Singh. Tilak Singh said that Asha Rani's case will be, Asha Rani's case was regarding gratuitous passengers in goods vehicle. Tilak Singh said that will be applicable to passengers traveling in private vehicles also. The question came up because they have submitted from the very beginning that they were gratuitous passengers. that word gratuitous has made they are saying that we have exemplary cost is to be imposed, exemplary something is to be imposed, that we should be like hammered, Lordship. But the thing is, who started that? That word gratuitous was used by them in their claim petition, in their evidence, as well as in the judgment. 2 or 3 times it is mentioned.
Okay.
Who started that?
Because
Before-
we didn't want to
before
hide
we-
anything.
We point one finger on others, 2 are pointing towards us, Lordship.
Okay, so this has also to be decided in this appeal.
Hmm.
Whether-
Yes, it has to be decided. That is a vital point for decision, Lordship. That if gratuitous passenger will be occupant too, because occupants, insurance companies are not filing any cases, Lordship, for occupants. Here, why the question came? Because they said they are gratuitous passenger. They started the war, not us. We were defended.
Now, if
Their-
your lordship will kindly see the policy on which, my lord, much emphasis is laid. Does it distinguish between gratuitous and occupant?
Yes, because they
Where is that distinction?
250 rupees was paid for occupants of the vehicle, Lordship.
Gratuitous passenger, no compensation is payable? Well, there should be a limit to
that
misleading the
amount-
court.
No, Lordship, that amount is to be paid from the insurance company, not under MB Act. I submitted that in my argument, that they are not covered under the MB Act, Lordship. That 1 lakh rupees, if at all it is to be paid, it is to be paid directly from the insurance company to the claimants, not through the MB Act. MB Act does not cover that, because that is the policy.
Okay, I will clarify.
That
Now,
is the-
any other submission?
Yes, and Lordship, that time I did not get that service book, they said. Lordship that time told me that exhibit 17 is the original of exhibit 32, or 32 is original of.
32 is the original of. That is how PW3 had made his.
Yes, Lordship, then I would like Lordship to look at exhibit 17 as well as exhibit 32 at the same time, Lordship.
Only that correction is there in the.
No, not only correction. That's why I'm showing Lordship. Lordship will see not correction. Lordship, I think 17 is at. 17 is at page 59, Lordship, and 32, 101 of LCR, Lordship.
Yes.
Lordship, now, since both the documents are before Lordship, Lordship will find the correction. Correction, Lordship, I want to understand what is the correction. Is it 1 of 2 or 2 of 1? First of all.
2 has been made 1.
2 has been made 1. Lordship, but that won't be correct, Lordship, if my mathematics or my mobile's mathematics is okay, Lordship. That the 2 cannot be corrected as 1 because it comes to 2 only. So maybe my mobile is wrong or submission of the council is wrong. Secondly, Lordship will find this is dated, the signature of principal 21/2/18. And in 32, Lordship will find it is of 2019. Are this the original of 17? Is this the original of 17?
Okay.
Not only the difference in the calculation or the overwriting, which the court has relied upon, the 2 signatures are there in 32, and it is dated in the year 2019, 1/6/2019, and also 13, one other signature is there, 13/8 something, and here it is 21/2/18. How could the court then take this up, Lordship? These 2 documents are not same. They are saying at different times, different amounts can come up. That's why 16 came, 17 came, 32 came. Income tax documents are there. And since there was a very big increase to 47,700, as the service book is and the person who came to prove that service book, Lordship, he says in his cross-examination that I do not know anything about that. The notice from the court is read out. In that notice, particular person is asked to come, and the person who came, he does not know anything.
Okay.
this is a clear case of either remand or the compensation goes back to, say, 3,000 rupees notional income or something like that, Lordship.
Okay, both of you gave gist of your written submission.
On
Yes,
24th.
On 24 or 25, what heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. S. Datta, learned senior counsel assisted by Mr. M. Talukdar. Yeah. This is item number. Your M. Talukdar. M. Talukdar. The counsel for both the sides are requested to submit a brief written gist of their respective arguments on the next date fixed. When 25th,
24th, or 20, as your lordship pleases, my lord.
let it be on 25th.
25th,
No, it should be on a hearing date.
26th, 25th is Wednesday, Lordship.
24th is Tuesday, so 24th is better, it's a hearing day.
24th.
I understand, my lord, that will not be required to address your lordship again.
I want to address on one more point, Lordship. About he submitted that the withdrawal was not allowed by us. Lordship, this is a case of 23. We agreed to do the hearing first, and time and again, they have been taking time in hearing. Last date also, they took time, practically. So, Lordship.
That your
the
lordship
question-
will ascertain from the records, my lord. I don't want to
Yes,
make any
records
submission on that.
Can show the dates. And Lordship, that is why out of turn hearing of this case was done, so that there is because there is a big question to
On
determine.
26.
26th.
26.
We will
Then-
be submitting it to the bench assistant.
Bench, court master.
Yes.
You have to let this case be listed again on 26/9/2024 as part heard matter.
Part heard, Lordship.
Part heard, otherwise it may not come to this court. If-
Yes.
Lordship, part heard shakes me like part
No,
heard, like-
I will do no further hearing.
Okay.
Only you have to submit.
Fine,
Part heard matter only because I have experience. Unless I mention part heard,
Yes.
it may get lost in the registry. It may go to some other court.
No, fine, Lordship.
Oblige.
Highly obliged, Lord.
Judgment will have. Judgment will get a belek file of argument.
May I please?
Yes, brief.
Yes, Lordship.
You are pressing for long incarceration.
Lordship. For long incarceration and long incarceration and or inordinate delay in the case, and since last 9 months, no progress in the trial, and I will support my judgment argument with Muhammad Muslim and Viraj Shukla's judgment for inordinate delay.
Which case?
Muhammad Muslim Viraj Shukla.
How many days you are behind the bars?
641 days.
What it comes to?
1 year, 9 months, 6 days. Then for a delay, we have some more judgment, Sitta Bishwas, which was granted bill after 1 year, 6 months, 17 days. Then Shariful Islam also I will list, and which was given granted bill 1 year, 6 months. Nitish Adhikari, Vatsat, West Bengal.
In
1
this
year,
case, how many accused were already granted bail?
1 accused.
Only
Ari
one.
Arvind.
Yes, Ms. Das, on long incarceration, 1 year, 9 months.
Similar set of allegation, Lordship.
Third, Mr. M. Rahman, learned counsel for the petitioner in bail application number
59.
2259. heard Mr. Rahman, learned counsel for the petitioner, also heard Ms. N. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Ibo Maya Thapa, who has been detained behind the bars since 17/12/2022, within bracket, for last more than 1 year, 9 months.
6
bracket,
days.
Bracket close. In connection with special NDPS case number 42/2023, corresponding to Lumding PS case number 201/2022, under section 2 within bracket small b within bracket small Roman 2 within bracket capital C/29 of the NDPS Act, 1985. The gist of accusation in this case is Code Para 3. Rima. I am marking it. A Code Para 3 from page 46. 46. Code Para 4. Which vehicle you were driving?
Actually, I was driving the truck.
Stop. Next para. Learned counsel for the petitioner has submitted that though the charge sheet in this case was laid on 29/4/2023, and though the charge was framed against the petitioner on 29/9/2023, however, till date, out of 6 listed prosecution witnesses in the charge sheet, only 2 have been examined. And even after prolonged incarceration of more than 1 year, 9 months undergone by the present petitioner, the trial has not progressed, and there is no hope of culmination of the trial at the earliest. Stop. Hence, he has submitted that the petitioner is entitled to get bail on the ground of prolonged incarceration only. Stop. Learned counsel for the petitioner has also submitted that in the meanwhile, one of the co-accused, namely Yaruibo, Yaruibo, has already been granted bail by this court on 25/6/2024 in bail application number 4205/2023. Learned counsel for the petitioner has also submitted that though in the present case, the quantity of contraband which is involved is commercial quantity. However, as the petitioner has undergone prolonged incarceration and there is no hope of early disposal of the case, comma, and the trial has not fairly progressed, comma, his right guaranteed under Article 21 of the Constitution of India outweighs the embargo of Section 37 of the NDPS Act, 1985. Stop. Code para 11 from page 47 of the Code para. No. On the other hand, learned additional public prosecutor, Ms. N. Das, learned additional public prosecutor, has opposed the grant of bail to the present petitioner on the ground that commercial quantity of contraband is involved in this case, and therefore embargo of Section 37 of the NDPS Act is applicable to this case. Stop. Code para 13. Code para 14, 15, 16. 17, 18, 19, 20, 21. No, 19, 20, don't quote 21. In the present case also, the petitioner has been detained behind the bars for more than last 1 year, 9 months, and trial has not fairly progressed. And in view of the facts and circumstances of this case, as well as considering the observations made by the apex court in the ruling cited herein above, wherein, it has dealt with the question of long incarceration of similarly situated petitioners who were before the apex court, this court is of considered opinion that in the instant case also, the facts and circumstances are such that the long incarceration of present petitioner has that in view of long incarceration of the present petitioner, his fundamental rights guaranteed under Article 21 of the Constitution of India outweighs the embargo of Section 37 of the NDPS Act, 1985. Stop. The petitioner is therefore, entitled to get bail on the ground of prolonged incarceration. Code para 22 with changes. Instead of 50,000, make it 1 lakh with 2 sureties of like amount. 1 surety should be the local resident of state of Assam with certain conditions. Next, one more case is there. Same date of arrest.
Same date of arrest,
Same order. Petitioner নাম চেঞ্জ করে দিব মুখ দেখাবো পিছত same 1 lakh each with certain conditions.
highly approved.
Yes.
May I please, my lord, in case, my lord, I have prepared written argument, my lord, with supporting document. my
What is
lord.
the case?
Yes, the railway incident, my lord. Railway incident, my lord, against the judgment of the railway tribunal. Guwahati.
Railway Claims Tribunal.
Yes, Guwahati bench. The claim was dismissed by the tribunal. My lord, on 2, 3 ground, my lord. First ground, my lord, the tribunal not believe.
No, before claim, what was the case? Why you went to the claims tribunal?
Husband of the appellant herein that is alleged to have been died in a railway accident. And
Okay,
if that happens, my lord, then they are entitled to a compensation under the provisions of the Railways Act. Now, to sustain
under the provisions of Railways Act.
Railways Act, and to sustain a claim, my lord, for compensation, two things have to be proved. Number one, that the victim was a bona fide passenger. Bona fide passenger is one who was traveling in the train with a valid journey ticket. And
Valid journey ticket.
ticket. And number two, the second condition is that the person had fallen down from a train carrying passenger. That is, the fall should be an accidental fall. Now, if these two things are proved, then the
He has to fell down.
he has
Suppose
to
he-
fall down.
Yes,
He has to fall down. Otherwise, if he's inside the train, he won't die, my lord, or he won't get injured.
if some accident happens within the compartment.
Then also it would be, but here it's a case of falling down. My lord.
Okay.
In case of falling down inside a compartment, nobody would die, my lord.
No, suppose if he dies.
Then you'll be entitled.
Okay, no, you are submitting about the conditions.
But definition says that it's an accidental fall from a train carrying passenger. Definition says, definition.
Okay, we'll come to that. Yes,
Yes, ma'am. Even, my lord, a person having, my lord, platform ticket, if he dies, my lord, for any reason, he also will get.
Yeah, platform ticket, yes. That is provided
My
by
lord,
the Act.
should I go through the judgment, my lord, entire judgment, or my lord, this, my point, my lord? Judgment is a quite long judgment.
no, you argue as per your. You tell me the brief facts,
Yes.
on which date, what has happened,
My lord.
and
On
the claims tribunal allowed your
Dismiss
the claim.
dismiss.
What was the reasons for dismissal?
My lord, and my lord, tribunal held that he was not a bona fide passenger.
Okay. Which is a requirement for claiming
Because,
compensation.
because not that the ticket was not there, because that the police in their report not mentioned that he was holding a ticket. That is the reason. In fact, my lord, ticket exhibited by the claimant,
It was not considered.
not considered, and no, not considered, a reason also not given, why not consider? Only mentioned that the police report, this report of the department said that ticket was not seized. In their report, it is not mentioned about the ticket.
Yes.
In paragraph 16, my lord,
Page,
in paragraph 16, that observation is there.
para 16 of
Yes.
which
Of
page?
the judgment, of the judgment, my lord.
Judgment is at which page?
Yes. My lord, enclosed with the, my lord, is appeal, my lord.
Page 13. If he reads out the entire judgment, it would be beneficial for all because
Yes, read up.
everything would come out.
Yes, my lord, yes, my lord.
Everything
We
is
will
recorded.
come to know about this story.
Right. My lord, judgment. This application is filed under section 16 of the Railway Criminal Tribunal Act 1989 by the applicant for compensation on account of the death of her husband, late Dhiren Das, who.
No, you are not very clear. You have to read out so that I understand.
On jury sound.
This application is filed under section 16 of the Railway Claim Tribunal Act 1989 by the application for compensation on account of death of her husband, late Dhiren Das, who allegedly died in an untoward incident. Paragraph 2. Brief history of the case of the applicant is that her husband, late Dhiren Das, purchased general class ticket, journey ticket number also mentioned, dated 27/12/2012 for traveling from Bandel Junction station to New Bongaigaon station of Kamrup express train number 5959 on 27/12/2012 at Bandel Junction station. When her husband attempted to board the said train, he accidentally fell down from the train, sustained grievous injury, and succumbed to the injury sustained. Immediately after the incident, he was taken to District Sadar Hospital, Hooghly, where the doctor, after examining, declared him dead. Accordingly, the matter was informed to the in charge Chinchura police station through memo number dated 27/12/2012, which was treated as Ejahar. On the basis of said memo, the Chinchura police station registered UD case number 472 of 12. The dead body of her husband was handed over by the police after post-mortem examination to her relative to perform ritual rites. Her husband was sole earning member. She and her two sons, Deepal Das and Sanjay Das, aged 22 and 20 years respectively, are the dependent legal heir of the deceased husband. Para 3. The respondent railway filed a written statement denying the averment made by the applicant. In the written statement, the respondent aver inter alia dead. It does not admit that the deceased husband of the applicant had fallen down while attempting to board 5959 up Kamrup Express at Bandel Junction. It also aver that the FIR memo issued by the station master BDC dated 27/12/2012 clearly stated that one unknown person knocked down from a passenger special BDC and serious injury and sent to senior DMO Chorchora Hospital. Also informed to GRP BDS RPF BDC for necessary action. The applicant has failed to produce death certificate. It is not required still, my lord, observation is the death certificate of her deceased husband. The applicant to put furnish strict proof of bona fide of the deceased as a passenger and also put to furnish valid authentic document issued by competent authority to prove her relationship with the deceased. With these averment, the respondent pray for dismissal of the claim application with cost.
Which is the relevant provision of the Railways Act?
Compensation is payable under section 124A.
You read 124A first.
Yes.
Then you.
Yes, my lord, I'm reading. One 124A.
Yes, please read.
A compensation on account of the untoward incident. When in course of working a railway, an untoward incident occurs, then whether or not there has been any wrongful
Railways
act,
Act.
neglect or default on the part of the railway administration, such as
Okay,
My lord, provided, my lord, this is important in my case. The second part, provided that no compensation shall be payable under this section by the railway administration if the passenger dies or suffer injury due to A, suicide or attempted suicide by him. B, self-inflicted injury. C, his own criminal act. D, any act committed by him in a state of intoxication or insanity. E, any natural cause or disease or medical or surgical treatment unless such treatment becomes necessary due to injury caused by the said untoward incident. So these are the exceptions where a person,
okay, now come again to the judgment.
yes. My lord, para 4. On the above pleading of the parties, the following issues were framed for
Okay, skip
determining.
para 4,
Para 4.
come to para 5.
Yes. Para 5, the applicant filed certified copy of the memo dated 27/12, certified copy of inquest report, certified copy of investigation report, along with its English translation, certified copy of post-mortem report along with type copy, photocopy of the cremation certificate issued by the Chanderan Gor Municipal Corporation, original railway journey ticket dated 27/12 from Bandel Junction to New Bongaigaon, certificate issued by Sri Robin Thakuria, Government Gaon elector photo I-card of Srimati Jayanti Das, voter list, certificate dated 2/2/2016, issued by Secretary, number 41, Nong Piju Pada, Gaon Panchayat, Nagar Beda, Kamrup, in Assamese language, along with its English translation, an affidavit of Srimati Jayanti Das and Sri Krishna Prasad Chaudhary, marked as A1 and A12, 2A12, respectively. On the other hand, the respondent filed DRM report marked as R1. Para 6. After hearing learned counsel for the party, the perusal of record, issue-wise discussion, issue-wise finding are as follows. Issue number 1 to 4. Para 7. Para 7, my lord, is quoted, my lord, from the DRM report. Divisional Inspector RPF E Railway, in his investigation report dated 30 of August 2016, which is accepted by the Divisional Railway Manager, Howrah, and which is part of Exhibit R1, filed by the respondent, reads as under. On the material date 27/12/12, two number of untoward incidents were occurred due to fallen from the train, out of which one is female and another is male person. But in both incidents, victims' names are noted in the SM's diary as unknown. After the incident, SM's bundle immediately arranged to send the victim, unknown male, to Imambara Sadar Hospital, Chinchura, for treatment and issue a memo to the medical officer, Chinchura, with a copy of GRP bundle, white memo, so-and-so dated 27/12/12, and made a station diary. Though in this regard, no information is available with RPF post of the bundle, after death, hospital authority informed the matter to local PS Chura, and as per information, local PS Chuchura attended the hospital, took up the charge of dead body for further legal formality regarding UD case number 472 of 12, dated 27/12/12, removed the corpse and sent for postmortem, which was done at the same hospital. During investigation, I of the local PS Sutura Hugli came to know the name of victim is mentioned above and also learned that the victim, namely Dhiren Das, fallen from the train at Bandel railway station, platform number 2, got injury and died at hospital. After completion of investigation, local PS Chinchura Hugli submitted the final report in which he concluded that there was no foul play behind the cause of death. As per police document, there was no mention about the railway journey ticket. So from this report, 2-3 things my lord came out. In fact, my lord is in my favor. Next, my lord. Further investigation was conducted by the RPF official of Bandel, who submitted the investigation report in which he stated that there is no evidence that the railway administration regarding falling down of Dhiren Das from running train number 15959 of Kamruk at Bandel railway station, platform number 2. The incident might have taken place out of railway premises of Bandel station. If such incident taken place at Bandel station, the same must be noticed by any railway employee of Bandel. As Bandel railway station is a remote place where RPF, commercial and other railway employees are performing their duty round the clock. However, there was no mention about the railway ticket. Subsequently, it is not established that the action now was bona fide railway passenger, rather a trespasser railway premises. Accordingly, the claim of the compensation made by the petitioner appeared to be improper. The RPF officers has not prepared the site plan of the form 2. No information was available with RPF was SM Bandel. Under the above circumstances, the railway administration is not liable to pay compensation to the petitioner. Paragraph 8. Exhibit A1 is a copy of memo dated 27/12/12 addressed to in charge of Chinchura Police Station by Dr. Ujala Nandi, medical officer of the district hospital Hugli, wherein she has stated that one unknown male person aged 60 years, approximately, address of whom is not known, has been brought there to emergency room of hospital on 27/12/12 at 6:40 p.m. It is further stated therein that as per information given by the person who brought the dead body, the disease has fallen down from train at platform number 2, Bandel station. Peru's memo shows that the person with Mohammad Pappu, Sushant Singh, Anjan Singh, and Mohammad Anil, who brought the dead body, have also signed on it. However, their residential address is not mentioned therein. So, 4 persons violated took the injured person in the hospital. The name is mentioned here. Para 9. On receipt of information from Ujjala Nandi, medical officer of the district hospital Hubli, Sri S. Bhattacharya, ASI of police. My lord, this police officer not from my lord the railway. This is from my lord general police. Police. Chinchura Police Station, Hubli conducted the investigation and prepared inquest report on 27/12/12, marked as Exhibit 2. On perusal of A2, it is seen that the serial number 3, named as a resident of the disease, the investigation officer stated unknown age 60. However, below it, someone with different handwriting, wrote letter, age known, name of disease, Dhiren Das, HM age 60 years, son of late Ambika Das of village Pijupara, POPS, Nagarbera, district Kamrup. Similarly, at the serial number 4, date and hour of the death and how court, the investigation officer stated on 27/12/12 at 6:40 p.m. due to broad death, the beloved someone with different handwriting wrote fall from the train bundle, station platform number 2, 8. Serial number 5, place where cops lie with distance and direction from the police station. The investigation officer stated the dead body was found at broad date of emergency district Sadar Hospital, Hubli, 1/4 kilometer north. Para 10. Exhibit A3 is the investigation report under section 174 CRPC prepared by Samir Kumar Bhattacharya, ASI of Police, Tinchura Police Station, District Hubli. Since Exhibit A3 is written in Bengali language, the same was translated into English by Sri J. Hawk, the counsel for the applicant. Perusal of exhibit shows that the investigation commenced on 18/12/12, 7:30 hour and closed at 8:48 hour the same day. The exact translated version of the A3 is under. Name, parentage, residence, age of the deceased, unknown male, may be Hindu, aged about 60 years. Place where body was found. The dead body was found at emergency unit room lying on the trolley of District Sadar Hospital, Hubli. 3. Description of the court.
We can skip this. Skip paragraph 10, come to para 11.
11, yes. On careful perusal of exhibit A1, A2, N3, it is found that these exhibits contradict each other. As per exhibit A3, till closing of the investigation at 8:48 hours on 28/12/12, the identity of the dead body remained unknown. However, in exhibit A2, though the investigation officer who prepared it on 27/12 wrote against name, age, residence of the deceased, age unknown, age 60 years. But later on, somebody with different handwriting wrote the name of the deceased as Dhiren Das. That shows that this was done with malified intention and to deceive the tribunal. Beside, in exhibit A1, written issued by the Dr. Ujjwal Nandi on 27/12/12, it is stated that Mohammad Pappu, Sushant Singh, Anjan Singh, and Mohammad Anish brought the dead body and informed that the victim fell down from train at Bandel Station, platform number 2. But in exhibit 3, surprisingly relying on the statement given by the witnesses Binu Dom and Sri Shakti Sarkar, who were not in the picture on 27/12/12, as per memo issued by the doctor, the investigating officer formed an opinion that the victim died while attempting to board the train, fell down and sustained injury. Well, as per postmortem report marked as exhibit 4, the postmortem of the dead body of the late Dhiren Das was done on 20th of December 2012. In exhibit A4, the injury observed on the dead body of the deceased was as stated, abrasion injury over left foot, B, abrasion injury over left forearm, C, fracture of temporal and parietal bone, both sides, D, fracture ribs fourth and sixth. Fourth to sixth rib, both sides. E. Scalp. Scalper. Hemorrhage. Intracerebral hemorrhage and cause of death of the disease is stated to be due to intracerebral hemorrhage. And above mentioned injury, the antemortem in nature. Exhibit A4 is it cannot be ascertained that the death of the victim was due to the train accident. It is also not clear from the record who identified the dead body of the victim as Dhirendas. Para 13. In the station diary, which is part of the exhibit 1, on 27/12/12, 2 cases of train accidents have been found recorded therein. The gender of the one victim is stated to be a female and the other of a male. Against male victim, serial number 27, it is stated that one unknown person who knocked down by the passenger special BTC and seriously injured, and he has been sent to DMU to the hospital. But according to the applicant, her disease has been while attempting to board the Kamrut Express train 5959 up at Bandel Junction, accidentally fell down and sustained grievous injury and succumbed to the injury sustained. The substantiate its claim, the applicant filed original general class ticket, journey ticket number so and so dated 27/12/12 from Bandel Junction station to New Bongaigaon station. It is not understood as to how original ticket came into possession of the applicant. There is nowhere in the police report there is mention of seizure of original railway journey ticket. The applicant has also not mentioned disclosed by whom the ticket was handed over to her. There is no doubt about the fact that 2 persons, one male and one female, reported to have died in the train accident as station diary, but it is not proved by applicant that it was the husband who had died in an untoward incident. Paragraph 14. During cross-examination of the applicant, it one stated that she had not seen her husband purchasing railway ticket, journey ticket, boarding a train and falling down from the train, but she heard the news of her husband's death from police. She also stated that she had not seen the dead body of her husband and the cremation of her husband's dead body was done at Kolkata. That applicant also produced Sri Krishna Prasad Chaudhary, who she claimed to be an eyewitness of the incident. In his deposition, yet to Chaudhary stated that on 27/12/12, when he was waiting at platform to Bandel Junction, he saw a male person falling down on the railway track while attempting to boarding a train. Soon after the incident, a huge crowd gathered, and thereafter he left the place where he had to board a train. He also stated that after 15-20 days of the said accident, he came to know that the person who fell down on the track was his maternal uncle Dhirendas. In his affidavit, he has nowhere mentioned that the victim has his maternal uncle. It is surprising that anyone too would not recognize his own uncle from the distance away from that. He came to know that the person who fell down was his maternal uncle after 15-20 days from the date of incident. This statement does not inspire confidence and is not found trustworthy. It is also surprising that the applicant herself did not see the dead body of her husband. Taking an overall view of all aspects lead to inevitable conclusion that the story projected by the applicant is not creditworthy, and therefore it cannot believe that and creates doubt in the mind of this court to accept the plea of the applicant. Considering the facts stated above, the evidence available on the court, it is held that the applicant has majorly failed to prove that the deceased died on 27/12/12 in an unfair incident as defined under section 123C of the Railway Act 1989. Thus, it is held that the deceased was not a bona fide passenger of any train on the date of incident and died in an unfair incident. My lord, next, lordship may come, my lord, this document, my lord, exhibited by the appellant, HPW1. My lord, evidence part, my lord.
It is in the trial court record or you have annexed?
It's in the LCR, my lord, the documents have not been annexed. The LCR.
Documents are there in LCR.
In the LCR, all the documents.
So evidence of my lord, this AW1, Jayanti Das, who is the appellant here. These documents are, my lord, very important.
Which document you are referring to the evidence of AW1?
My lord, Jayanti Das, yes. My lord,
Probably it's page 35 of the LCR.
Page?
Probably. The
Page-
cross-examination is at page 41. The evidence in chief, maybe it's at page 35, the LCR. The page number is mentioned on the top right-hand side of the documents.
These are pagination is also not proper.
It's there, my lord, the paginations are. Not the side on which the court orders are there. On the other side, the documents are there, my lord. In the document side, at page 35, my lord, probably. On the top right-hand corner, the page numbers are written out there in small letter.
No, but it is not seriatim is not maintained. Page 35.
Probably. The cross is at page 41. I'm sure about that. And probably
it
the
to me,
chief
give it to
part
me.
is at page 35.
If I'll reflect. Yes, you make your submissions. I am listening.
my lord, I am relying on, my lord, these are document exhibited, these are important, my lord.
At which page?
Eight number of document.
This is page 35.
My lord, I am trying to read, my lord, the evidence on the affidavit of Jayanti Das, my lord.
Yes.
My lord, paragraph 4, other things, my lord, in the judgment it is discussed. In paragraph 4, it is like that, my lord, that immediately after the accident, the concerned police person of the Bandel Junction railway station had found the mobile number of my son. Deeplal Das, from the possession of the disease, and inform us through the said mobile number, and thereafter my son Deeplal Das along with my other relative rushed to Bandel Junction station, and after conduct of post-mortem examination, the dead body of my deceased husband had received from the concerned authority, and cremation was done at Borai, Chanditala, Burning Ghat, Chandir Nagar, Hugli. So, my lord, these facts, my lord, nowhere discussed by a tribunal, my lord. That, my lord, the number was found from the possession of the disease by police, and police informed of her mobile phone, and there, my lord, her son received it, and he accompanied the certain relative and went there. Nothing discussed.
Okay.
My lord, next can you see, my lord, exhibit 1, exhibited by A1, JNP Das. This is, my lord, FIR lodged by none other than the doctor herself, lady doctor, my lord. It is handwritten copy is there. To the IC, Chinchura PS. Sir, this is to inform you that one unknown person, male, aged about 60 years, address unknown, has been brought that to show in their hospital on 27/12/12 at 6:40 p.m. with fall from train at Bandel Station, platform number 2, as stated by accompanying person. So, my lord, can you see the first of all, my lord, this is FIR lord by a independent, that is my responsible person, my lord, a responsible person, a doctor herself. Exhibit 1. And in the said FIR, my lord, who brought the dead body, my lord, it is mentioned, it is discussed in the judgment itself. Muhammad Pappu, Sushil Singh, Anjan Singh, and Muhammad Aziz. These 4 persons, my lord, took the person for treatment, thinking that perhaps he survived. So, my lord, their name is recorded in the FIR, and their signature also obtained in the FIR. Can you see? It is their handwriting. The 4 persons who brought them, brought the person, their handwriting is there. So, my lord, it is a, my lord, why the tribunal not believe this document? They are not known because he is not an interested witness, my lord.
Tribunal has doubted the difference in handwriting.
My lord, I am coming to that, my lord. Exhibit 2, my lord.
Doctor is not an eyewitness to the incident, my lord.
Right, it is impossible. Person died, my lord, 600-700 kilometers away.
That is not the original FIR, my lord. This is the original FIR. Maybe it's part of the record.
Original FIR is there.
Yes, it's issued by the station master, my lord.
No, my
Clearly
here,
stating.
my lord, two stories there. First, my lord, this is the what I exhibited. My lord, it appears that.
What is exhibit two?
Yes, two is the, my lord, is a PBR form.
What is PRB? What PRB stands for? PRB form number 53.
Yes. It is prepared, my lord, by the officer in charge police.
No, what this PRB stands for?
I am also under rule 272.
No, if you want
Yes.
compensation, you have to answer my query.
Right, my lord.
This is a form in case of reported case of unnatural death.
Yes. Sent to magistrate under section 174 CRPC. This document, my lord, above, Bengal form 5570, it is this rule cited by my lord, perhaps my lord, it is the rule of West Bengal. The report of reported case of unnatural death sent to magistrate under section 174 CRPC code. My lord, this is prepared by the police. This is prepared by the police. And my lord, what is doubted, kindly see, my lord, the column number 1. Column number 1 is the station number, date and hour of information. Chinchura, PSUD, case number 472-12, dated 27-12-12. At 9:05 hour, 19:05 hour. Serial number 2, name and address of the persons. Dr. Ujjwala Mandi, EMO of District Sadar Hospital, Hooghly. Serial number 3, name, age and resident of the disease. First it is written unknown, aged 60 years. Later, age known. Later age known, name of disease, Dhiren Das, son of late Ambika Das of village.
Okay, it is okay, but the observation of the tribunal is that this handwriting appears to be of a different person.
Yes, my lord.
On that, what is your submission?
My lord, my submission is this. My lord, this document prepared by the officer in charge of the railway station outpost. So, my lord, it was the duty, my lord, of the railway authority to, my lord, call this person to clarify. My lord, they did not call any witnesses. It was their duty. Whether how the petitioner can, my lord, subsequently add the name, the lady.
Okay.
And my lord, 2 is the certified copy. Whatever I exhibited, my lord, exhibit 2 is the certified copy. And signature of 2 police officers here, there, my lord, below, kindly see, my lord. 2 police officers. One is OC, one is IC. Below, my lord.
Okay.
My lord, next document, my lord, I exhibited, my lord, exhibit 3 is, my lord, a report under section 174 CRPC. My lord, it is a paragraph 8 is, my lord, important. It is also translated copy, my lord, is there. Kindly see, my lord, this column 8, translated copy. Below signed witness informed date on 27/12/28 at about 6:05 p.m. at Bundle railway station in platform number 2 when the disease attempt to board in the train due to slipping of leg fall down from the train and sustained injury, and the local people took the district Sadar Hospital Hooghly, and Dr. Ujala Mandi on examination declared death. Column 9, my lord. What the police officer saying? I agree with the opinion of witnesses. So, my lord, the investigation officer himself stated that I agree with the opinion of the witnesses. Even then, to ascertain the actual cause of death, the death was referred to doctor for conducting post-mortem examination. My lord, next exhibit, my lord. 6.
How the tribunal has dealt with this exhibit?
Yes.
Tribunal has stated that the witnesses have not put their signatures. So therefore, he has not.
Tribunal has said that the witnesses whose names appear in this document are not the persons who brought the
took.
dead body. These persons were nowhere there in the scene. One is the ward master of the district hospital, my lord.
I'll come to you.
Yes.
This
My lord, exhibit 6 is the, my lord, railway ticket.
exhibit.
Railway ticket. Traveling ticket. It was the general class ticket.
This can be procured by anybody.
My lord, it is impossible to procure because, my lord, it is issued by railway clerk, my lord, their respective railway.
No. What is there? How it can, you can connect this ticket to the deceased?
Yes.
That it was purchased by the deceased.
My submission, my lord, after the death, my lord, nothing was seized or found from the deceased. And it cannot be believed the police or investigation officer or DM or he was carrying nothing. Even mobile number found by police. My lord, 2 police are involved in this case, my lord. The general police and the RPF. RPF, my lord, different version, and general police, my lord, which my lord started their investigation on the FIR of my lord, the Dr. herself, on the FIR of Dr. herself. And second set of my lord, this story, my lord, what my lord developed later on, my lord, it was the railway authority. And other 2 documents, my lord, my relation, my lord, voter list that I am reading.
No. Before going to other 2 documents,
Yes.
who exhibited this exhibit 6?
Railway ticket, my lord, the wife.
Wife.
Yes.
From where she got this ticket?
My lord, because, my lord, she stated in her paragraph 4, my lord, that as soon as accident occurred, the police informed her son while getting the mobile number, and they went to the spot with relatives. And that is why, my lord, after 3 days, my lord, dead body was cremated, and whatever belonging, my lord, they collected and took in their possession.
So this ticket was found from the.
Certainly, my lord.
No, is there any averment to that effect in whether the APW1, whether she deposed that I collected this ticket, from where she got the ticket? Before exhibiting that,
Yes, ma'am.
I have not gone through the evidence. I am just putting a query.
I am also,
Whether-
I am not getting such a statement, my lord.
Then
But my lord, I am coming, my lord, later on to that, my lord. And my lord, thereafter, can we, my lord, can we see that?
whether PW, the witness number 1 was cross-examined,
Yes, ma'am.
whether question as regards ticket was posed to her.
She said that, no, it's at page 41 of the LCR.
Okay,
She
let
said
him
that
complete. Yes, Mr. Chauhan. This you have to address from where she got the ticket. How the tribunal was wrong in not relying on that ticket. Because exhibit 6 is one of the main document on which you are relying
Yes.
to claim that you were railway passenger on that day.
Yes. My lord, paragraph 3 of her evidence, my lord.
Para?
3, some glimpses there. That on 27/12/12, my deceased husband Hiren Das desired to travel from Bandel Junction railway station to New Bongaigaon by 5959 up train. And for that journey, my deceased husband had purchased a railway journey ticket by ticket number so and so dated 27/12/12 from Bandel Junction to New Bongaigaon at Bandel Junction railway station. As soon as my deceased husband attempted to board the train, he accidentally fell down from the train, sustained severe injury upon his person and died on the way to hospital.
She has not stated from where she got that ticket. Or whether she has stated or not.
My lord, it appears that she is not stated.
During cross-examination, any question was asked on that railway ticket.
Page 41 of the LCR. If I may just surprise your lordship, what she had stated. She had stated that she had not seen her husband purchase the ticket. She has not seen her husband board the train. She has not seen her husband falling down from the train. She has also stated that she has not visited Calcutta to receive the dead body. And probably she has also stated that the husband desired to travel from Kolkata to New Bongaigaon, not from Bandel Junction to New Bongaigaon. Probably that is the content of the
But
cross.
this question regarding ticket was not asked.
That's our case. It's a planted case. There was no seizure list by the police to indicate that the ticket was seized. In many of the cases which I have dealt with, my lord, if the ticket is recovered by the police, there is always a seizure list, my lord. It would be mentioned that these are the articles recovered from the dead body. In the seizure list, there is no mention of the ticket.
My lord, DRM report was my learned friend submitting. It is mentioned there. It is important also, my lord. In DRM report, my lord, dated 25/8/2016, Eastern Railway.
DRM report is an exhibited document.
No, my lord. DRM report, my lord, is dated 30 of August 2016. It was submitted in the, my lord, tribunal, and this document relied by the learned tribunal, my lord. Whether you worship God or not.
No, you tell me the page, only then I can
Yes.
find.
Serial number 1, name.
No, at which?
Document, my lord, dated 30 of.
There are so many documents. You pinpoint the page number, only then I can find out.
Starting point, my lord, page number 1, note. They mention as note, subject investigation report of untoward incident in case of death of Dhiren Das. And it is signed by, my lord, the 5 officers.
If I may indicate the page number, it's page 52.
Yes, why pagination
Page 52 of the LC.
section code. Itu record to রাখি থবো কারো কারবাক মাতিবা section piece of chamber আজি
my lord, it is, my lord, submitted in the tribunal and relied upon, my lord. This is dated 30th of August 2016. My lord, here, my lord, several.
No, Mr.
My lord.
Chauhan, you have to go through the record. Your pagination should tally with my pagination of the office record. Only then I can relate to what you
My
are.
lord, I have not paginated in my document according to my lord LCR.
Otherwise, your main basic submission is that that how you have to make submission how the tribunal was wrong in rejecting, in not relying on the tribunal mainly disbelieve your case because firstly it's observed that there were, according to the tribunal, there were different handwriting of some other person in the FIR or that inquest report. And that PW1 never stated how she got access to the ticket, from where she got the ticket, which railway ticket, which you have exhibited as exhibit 1,
6.
exhibit 6. So, and the FIR which was lodged by the, no, FIR by the doctor and the report under 174 by the police, the witnesses are different. On these issues you have to address.
That is why, my lord, my submission is the true set of, my lord, documents are there. My lord, firstly, my lord, the poor person took this, my lord, to the hospital. Thereafter, when the railway authority came to know, my lord, thereafter, station master prepared documents and document new FIR. That is why different in timing also.
Which is the other FIR?
My lord, what my learned friend was
Your
relying.
lordships.
No, but is that in records?
Yes, in the judgment itself, it's mentioned. First page of the judgment, last line. Accordingly, the matter was informed to the in charge, Chinchura police station through memo number so and so dated so and so.
Let me call somebody from concerned section to get the pagination corrected. We are fixing it on a later date, keeping it part-heard. You also submit your written argument, gist of the argument.
Sure.
And you answer my queries which I have posed to you. You have understood my queries.
Well, two queries there, my lord, regarding the ticket, my lord, and later on, my lord, inserted something, my lord. In
Ticket and observation of the tribunal that somebody else handwriting is there.
Yes. For my lord, that we have to go, my lord, through entire record.
Yes, and your submission should tally with the records. Pagination should tally.
Yes.
Before arguing, you should go through the record LCR so that you can, otherwise there will always be a disconnect. And
Page numbers are arranged in descending order, my lord. That's the thing.
no, this I will call this.
It's in descending order, not in ascending order.
No, first page start from 23. Page number 23 is the first page.
That's
Then
the order sheet, my lord. This is the order sheet side.
order sheet, okay.
And the document side is different.
63. Okay.
That's how the tribunal maintain their records.
Okay. Then you have to go through the record. If the pagination is okay, if it is in descending order, it appears to be in descending order.
Descending.
Then so that you can, while making submission, you can refer to the page number. Heard, when will you give written argument?
Written argument, my side, my lord, I have already submitted.
This was the first time it has come up for hearing. A hearing never took place in this matter.
No, several times, but not completed.
Okay, I'm
Or
keeping it
procedural
part.
time. My lord, one observation may be there, my lord. Remember, we may be allowed to, my lord, go through the record by the registry. Otherwise, my lord.
Ah, yes. Heard, Mr.
Look, I have not made my oral submissions on the next date probably. But
Yes,
we will give
yes.
some opportunity.
Yes, no, you will get full opportunity. Heard, Mr. S. Chauhan, learned counsel for the appellant. Also heard Mr. B. Sharma, learned standing counsel, NF Railway. Hearing remain inconclusive. The counsel for both the sides are requested to submit a written gist of argument on the next date fix. The counsel of both the sides are also allowed to go through the
LCR.
LCR. Registry shall allow the same. Stop. Let this case be listed again on when suggested it.
On 30th or 1st of October.
1st of October. On 1st of October, hearing date as a part heard matter.
Right. Right.
Lordship, I was expecting today our matter will reach, Lordship. Item number 14 and 15, Lordship. Lordship, I ardently pray, Lordship, let this matter be listed day after tomorrow, Lordship. On the 19th.
No, not before 23. After 23, you choose any day. Others will be left over.
26 then,
Okay, 26.
September.
26 September. Item number.
26, my lord, it will be difficult, my lord.
You are on the other side.
Yes, my lord. I am the appellant, my lord. This is the respondent. My lord,
Okay.
in 20, my lord, here we are led by senior counsels, my lord.
Okay, you suggested it then.
Lordship, here I'm.
Immediately after the vacation.
No, Lordship. I have adjusted so well with them. Every time I'm taking dates, I have talked to them. Last week, they said one of the senior advocate was not there, whereas he was very much there last week in this court. No, it cannot be, Lordship.
No, but if on 26,
Yes.
counsel is not present,
Lordship, this is going on since 2019, if Lordship reads the records.
therefore,
Only because senior advocates are engaged in this case, Lordship, it cannot be, Lordship, like this. Lordship will go through the record and see. Every time they make
I am
submission.
not taking up hearing now.
I know, Lordship. But
You
Lordship,
just
let it be on 26, if they're there, if they're not, because last week also when I.
He's saying that they will not be there.
Lordship, last week also it was told to me that one senior advocate would not be there, but she was very much there in this court. So Lordship my prayer should be accepted, Lordship. This is a very genuine cause, Lordship. Only senior advocates are not there, it cannot be.
No, they are engaged.
Yes, they are engaged. This is going on since 2019, Lordship, in this case.
On 3rd October.
3rd of October, my lord. Thursday.
Thursday, hearing day.
We will take a chance, my lord.
Let it be on 3rd.
Lordship.
3rd of October, yes, my lord, kindly, because otherwise, my lord.
On request of learned counsel for both the sides.
Lordship, Lordship, let it be on 1st of October, Lordship, I pray.
1st of October again.
There is no much difference between 1st and 3rd.
Because Lordship, again, they'll be not, I understand, Lordship, I understand, because again, the vacation will come, if it is left part hard, and again, Lordship can hear it on 3rd, Lordship.
Then it will remain, at least now it is not part heard. Heard. On request of learned counsel for both the sides. Let this matter be listed on 3rd of October.
I'm so obliged, my lord.
My lord, item number 16 and 17, my lord.
My lord, I've created, if possible, my lord, lordship may fix it in the next week, my lord, on 26, my lord. My lord, accident occurred in 2010, my lord. 16, 17, my lord.
What is the matter?
But this is a MSCT case, my lord. In 2010, persons died, my lord. There are no appeals, but issue is only with regard to contributing negligence, my lord. Only that part is there, my lord.
Okay, 26. Who is the other side?
Other side, my lord, my friend is there.
26. 16, 17 on 26.
Your Lordship, with reference to item number 26. So, Lordship, regarding the petitioner's name, in the last occasion also, their name has paid for listing of the reflection of the name in the cause list.
Lordship, my senior's name is not reflected in the cause.
At the same time, a date may be fixed for the same. Your
No
Lordship.
date. Item number?
26.
Whose name is not reflected?
Mr. D. Nath, learned senior government advocate.
Item number 26. Heard Mr. What is your name?
S.A. Bhakhtiar.
S.A. Bhakhtiar, learned counsel for the appellant. Also heard Miss.
Respondent one.
Sir,
I am for the respondent one.
Who is for the appellant?
Sir, Lordship D. Nath. His name may kindly be
Okay, heard
reflected in
Miss.
the cause.
Heard Miss
M. Sharma.
M. Sharma, learned counsel appearing for Mr. D. Nath, learned senior government advocate. Learned counsel for the appellant, who submits that the name of the engaged counsel for the appellant, namely Mr. D. Nath, learned senior government advocate, is not reflected in the cause list.
Your Lordship, a date may be fixed.
And no date. And she prays for doing so. Stop. Also heard Mr.
S.A. Bhakhtiar.
S.A. Bhakhtiar, learned counsel for the
Respondent one.
respondent number 1. The matter could not be taken up for hearing due to paucity of time. Stop. The registry is directed to
Lordship, a date may be fixed for it, next week or Thursday.
no
Lordship,
date.
the matter has been kept on pending.
Let me
since long.
complete the registry is directed to reflect the name of Mr. D. Nath, learned senior government advocate as engaged counsel for the appellant in the cause list henceforth. Let this matter be listed.
Thursday, Lordship, next week or Thursday.
No,
Otherwise, it will be kept on pending, Lordship.
Lordship, one correction. Actually, D. Nath, sir, is appearing as standing counsel PWD, not as learned senior government.
instead of government advocate,
SCPW.
standing counsel PWD. Registry to list this case.
My prayer is to list the date, Your Lordship.
No date. On a date to be fixed by it.
Please, your Lordship, item number 19 may be taken up after a week, would not be taken. Lordship, there is some urgency in this case.
What is the urgency?
Lordship, the urgency is from our side, Lordship, in the lower court as well. So, and it has not been taken up for a long time, Lordship.
What is the matter?
It's just the CRP.
Item number 19. Heard Mr. You are also there in
I'm
item.
for the respondent.
Heard Miss. Related to council name लिख दो. This matter could not be taken up for hearing due to paucity of time. Let this matter be listed after a week on a date to be fixed by the registry.
Obliged.